Go ahead.
All right, welcome to the winter meeting of the CBLS. We are now on the record. I'd like to call the open session of the meeting to order. And just be aware that for those of you who are on Zoom, just like a regular in-person meeting, it will be archived and recorded. So welcome everyone to the meeting. We're going to take items on the agenda in the order that they appear on the agenda. So you should have access to the agenda online. And any votes will be taken by roll call today. So we have Adrian here who will do roll call both for the initial meeting attendance and also for any votes that occur today. I'd like to start with a roll call. Adrian, can you go ahead and do that?
Of course. Vince.
Here.
Hammersmith. Here. Acosta. Alano.
Here.
Lee.
Here.
Levy.
Here.
Yoon.
Here.
We do have enough members at this forum.
Great. All right, I'd like to welcome our state bar staff who's present today. There's quite a few of you, so bear with me as I go through and make the introductions. But let's start with, so Leah Wilson, who is the Executive Director of the State Bar, will be attending remotely. Welcome, Leah. Thank you for joining us.
Hi.
Thank you. Donna Hershkowitz, who is the Chief Programs Officer of the State Bar, is joining us here in person. Good morning.
Good morning, everybody.
Amy Nunez, the Director of Admissions, is also here. Good morning, Amy.
Good morning.
And Audrey Ching, the Assistant Director of Admissions, is present. Good morning.
Morning.
Lisa Cummins, Principal Program Analyst for Admissions, is present remotely. Good morning, Lisa.
Good morning, everyone.
We have Jean Krasilnikov, who is General Counsel for Admissions, who is also present.
Good morning, and Assistant General Counsel. That is above my pay grade, but I am with the Office of General Counsel.
Okay,
So good morning,
great.
everyone.
Thank you. I didn't mean to give you an impromptu promotion, but we welcome you.
Declined. Thank you.
All right, Janelle Delacruz, Program Analyst for Legal Specialization.
Good morning, everyone.
Good morning. And Latrell Cabrigas, also a Program Specialist for Legal Specialization.
Good morning, everyone.
Good morning. Thank you all for joining us today. We appreciate all the work that you do for this program and your attendance here for our CBLS meeting. All right, let's move forward. We're going to have a public comment session to begin the meeting. And I want to just kind of go through the public comment process so that everyone's aware of the procedure. The Board of Trustees recently adopted a public comment policy that applies to all state bar committees, including this one. So we're going to be following that. The policy statement says that the State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. And that's true of this committee as well. We appreciate when someone comes forward with a comment. The comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct public business on behalf of the people of California in a timely fashion. Written public comments may be submitted to the email address on the meeting agenda, and we encourage written public comments at least 24 hours prior to the start of a public meeting. Written comments received less than 24 hours prior to a meeting will be distributed the following business day. If you bring written materials to a meeting for distribution, they'll be collected by the meeting secretary and distributed after the meeting concludes. For oral public comments, persons are encouraged to sign up to speak in advance of the meeting and will be called in the order that they have signed up. Persons attending the meeting remotely will be called in the order that they appear in the attendee list. And in a moment, I'll explain how to raise your hand to tell us what you want that you want to do that, assuming we have any public members here to provide comment. Those joining us in the meeting room today, we don't have any joining us today that I see. Okay.
No.
All right. And speakers cannot cede their time to another speaker. It does guarantee that all who wish to speak will have an opportunity to do so and facilitate hearing from as many members as possible. We encourage those speaking not to repeat points that were made by previous speakers. Simply state that you agree with the previous speaker to allow the committee the time needed to deliberate on important topics that it will be discussing today. We limit public comments to 3 minutes per person. As a reminder, the State Bar's anti-discrimination and anti-harassment policy says the State Bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. Employees must at all times treat all employees, job applicants, and persons providing services to the State Bar with respect and dignity in accordance with this policy. Likewise, the State Bar will not tolerate harassment, discrimination, or retaliation against its employees, applicants, or members of the public by any employees or by any person with whom the State Bar has a business, service, or professional relationship. If you are in Zoom and want to speak, you'll need to raise your hand unless you're already on the pre-meeting sign-up list. To do so, simply click on the hand icon that's at the bottom center of your Zoom window. If you're participating by telephone, you may virtually raise your hand by pressing *9. That's the star key and then the number 9. Our coordinator will call members of the public, starting with the pre-signups, then the Zoom list, and then in-person signups in the order that they raise their hands or signed up. Staff will enable microphones of the speaker, start the timer, call out when 30 seconds remains. Do we have anyone who wishes to make a public comment today?
We did not receive any pre-signups. I do not see anyone on a Zoom list, and we do not have anyone in attendance.
Okay. All right. So we will move on from the public comment portion of the meeting. And we also have no planned guests speaking today. All right, we'll move on to annual new member orientation. Adrian, if you could put up the PowerPoint for that. I'd like to welcome our new members. Welcome to the CBLS board, Michael, and we appreciate your joining us.
Pleasure to be here.
Great. Fantastic.
Is it reading the full screen or?
Oh, yeah, we can do full screen.
Yeah, so we can see them here.
Thank you.
All right, the purpose of the orientation is to provide guidance and give background and overall information regarding the CBLS and what we do. Some of the information may be new, some of it has been updated since the last orientation. So for those of us who were oriented before, there is some new information here as well. We also have Grace Alano and Michael Lee, who are new and didn't otherwise have orientation. So this will may be new for you. If you can change the slide. Next slide. We're going to start with California Rule of Court 9.35. This is the State Bar legal specialization rule, which states that a certified specialist is a California attorney who holds a certificate as a specialist issued by the State Bar of California Board of Legal Specialization or some other entity approved by the State Bar to designate specialists. And then we oversee the State Bar Legal Specialization Program, which is the program established to administer and certify legal specialists in various practice areas throughout California. Okay. The next slide. We'll go through the Board of Legal Specialization has a chair, a vice chair, and it also has at least 5 attorney members and up to 2 non-attorney public members who serve 4-year terms. In case you're wondering how long you signed up for. Okay. And then we have a number of practice areas which we do have specialty certification available in. They're identified here: admiralty and maritime, appellate law, bankruptcy law, criminal law, estate planning, trust and probate law, family law, franchise and distribution law, immigration and nationality law, legal malpractice law, taxation law, and workers' compensation law. The general requirements for certification to become a certified specialist include passage of a written examination, and that you've practiced law at least 5 years, depending, and spend at least 25% of the time in your specialty area. You also have to complete continuing education in the specialty area greater than that required of general licensees for the state bar, and demonstrate a broad-based and comprehensive experience in the specialty area to be certified as a legal specialist in California. All right. Let's see. Next. I somehow got off track here, Adrian.
Okay. I'll
Sorry.
continue this one. So for the, in addition to the 11 areas that the state bar directly accredits in, we also have state bar accredited organizations and areas. There are 5 accredited organizations that are recognized in California, and within those organizations, they have specific specialty areas where California licensees can get recognition. From the American Board of Certification, there's business bankruptcy law, consumer bankruptcy law, and creditors' rights law. Within the American Board of Professional Liability Attorneys, we have legal malpractice law and medical malpractice. From the National Association of Counsel for Children, they have juvenile law. From the National Board of Trial Advocacy, they have civil trial advocacy, criminal trial advocacy, family law trial advocacy, and social security disability law. And then last, from the National Elder Foundation, they have elder law. Once again, California licensees, they can receive certification from these state bar accredited organizations. Those organizations, they do manage their own certification programs, but they must have requirements comparable to what the state bar requirements are for our own specialty areas. And only certifications received by these organizations and in these approved areas are recognized in California. And then maybe just a quick data point. So as of December 1st, there were 377 specialists across these organizations and areas.
Okay, thanks, Adrian. All right, next. All right, so CBLS oversight, we are the board charged with overseeing the program, and we are overseen ourselves by the Board of Trustees, which is the state bar's governing body, which develops the guiding policies and principles underpinning its regulatory mission. It's comprised of 13 members. And so we take direction from the Board of Trustees. We were all appointed by the Board of Trustees to serve on this board. Next. We have additional governance that we adhere to. The Bagley-Keene Open Meeting Act applies to our meetings. We are now following Rosenberg's rules of orders, and we will learn more about that today. We follow State Bar Rule 6.20, which refers to delegation, supervision, and control, and 6.21, which deals with public communications. So with respect to the first two, they deal with how our meetings are conducted. The second two discuss how the entity's powers, duties, and authority are delegated by the board and subject to its supervision and control. 6.21 states that unless expressly authorized by the board or the rules of the state bar, a state bar officer, agent, committee, commission, or other entity may not act or purport to act, speak, or purport to speak for the state bar, make any public communication on behalf of the state bar, or circularize, poll, or put to the vote of all or a substantial number of licensees of the state bar any matter on which the state bar has acted or is empowered to act. So requires oversight for any public communications. Next. This is the state bar leadership. It shows exactly how the state bar is structured, you can see the Board of Trustees at the top, and then General Counsel, Chief Trial Counsel, and the Executive Director immediately below there. And from there, we drop down and you can see if you go all the way to the right, you'll see Donna Herskowitz as the Chief of Programs. And then down to the bottom left, the Director of Admissions, Amy Nunez, both of whom are here. And then the next slide shows the Office of Admissions with the Director of Admissions, Amy Nunez, at the top. And then the Assistant Director of Admissions down and to the left is Audrey Cheng, who's also here today. Then straight down, you'll see Legal Specialization, and there's Adrienne Galan, who is our Program Supervisor. All right, we'll talk briefly about the legal specialization rules. There are a number of rules that apply to the CBLS. These rules are provided for reference. We'll be discussing specific rules and processes later in the agenda. But just generally, 3.90 to 96, those cover logistics, including the composition of the board, authority, conflicts of interest, and handling confidential information. 3.110 to 3.113 covers the basic program details, including certification requirements, fees, applications, and reporting requirements. 3.114 to 3.119 cover additional program details, including education requirements, practice, and tasks, references, waivers, and modifications, and recertification requirements for specialists. 3.120 covers certification and recertification denials, including failure to meet certification requirements, pending disciplinary charges, lack of candor, and information bearing negatively on proficiency. 3.121 to 3.123 describe state bar action and an applicant's request for review. And rules 3.124 to 3.125 cover removal from the program and process for appeals, including the grounds for suspension or revocation and the process for appealing those. Finally, 3.126 covers the specialist designation as determined by the state bar. Okay, and then we'll go through the CBLS charter. So the board is composed of 7 members appointed by the Board of Trustees. Our charge is as follows: to establish a program to encourage attorney competence by certifying as legal specialists attorneys who have a demonstrated proficiency in specified areas of law, develop testing and legal education criteria for those specialists, recommend program rules and provide policies and guidelines for certification of specialists, recommend approval of additional areas of legal specialization and their related certification standards, and recommend other entities to grant certification. So some of you may be aware that we recently have been exploring a certification for specialty and privacy law. We have a working group that is working on that. And then we'll be talking today about recommending program rules and policies going forward and how we can be more involved in that process. The CBLS functions. So we establish, approve, deny, and request for new specialization areas. We're a policy-making body, so we look at policies and rules relative to the specialty program. Serve as outreach for legal specialization in terms of getting out and encouraging more attorneys to become specialists, and serve as an appeals body for all determinations relating to certified specialists. The legal specialization unit staff. Okay, let's see. This is the program supervisor, Adrienne, who we all know, program analyst, Janelle, and then the program specialists, Janice Luttrell and Anna Moreno. So generally, Adrian does everything. I'm sure that Janelle, Janice, Latrell, and Anna disagree with that statement. But as far as setting up our meetings, but Janelle is responsible for exam development, grading, contracts, accounts payable, legal specialty brochures, legal specialists, continuing legal education, and provider applications. So Adrian does not do it. Janelle does all of that. Janice is responsible for the bankruptcy, family, franchise, legal malpractice, admissions, wall certificates, and LS annual fees. Latrell handles the Admiralty criminal workers' compensation specialties, LSCLE compliance, and legal specialty wall certificates. Anna is responsible for the appellate, estate, immigration, and taxation specialties, any resignations, and judicial tolling. The staff is also supported by Amy Nunez, the Director of Admissions, who oversees all admissions, Audrey Ching, the Assistant Director of Admissions, who oversees legal specialization and assists the director, and Lisa Cummins, the Principal Program Analyst, who handles exam development, admissions, development of exam questions, legal specialty, exam development, and grading. So we have a lot of people who do the work to ensure that the legal specialization program is successful. Great, thank you.
And then actually, if okay, I did want to just make one other comment regarding the CBLS functions. So meeting topics, they will focus on policy outreach, new specialization areas, and appeals, which allows the CBLS to provide support based on their areas of expertise, and hopefully makes for a more meaningful engagement. So to meet these functions, the CBLS will move to items that focus on the CBLS charges within the charter, and also relating work to the State Bar's 5-year strategic plan. Our Executive Director, Leah Wilson, she will be providing us a presentation on the updates to the strategic plan. And this new focus, this was energized by the 2022 Work Plan Initiative to develop rule recommendations around enforcement of those inappropriately holding themselves out as specialists. So staff, we have identified a number of additional areas that are in need of rules to govern the legal specialist exam, as well as legal specialization processes, and hope to use the expertise of members of the CBLS to develop those. This will cause meetings to transition from staff reporting in to more meaningful and engaging discussion items. We will be going over how to keep the CBLS most engaged and focused as part of our planning session later in the agenda. So thank you, members.
Yeah, I'm really excited about the new direction of the CBLS, where, you know, we will become more engaged in setting some of the work plan, setting policy and guidelines, and overseeing the program. So thank you for that. Great.
Anyone have any
All
questions?
right.
Oh,
Any questions about the orientation process? Everybody ready to go? Fantastic. Okay, next item on the agenda is the approval of the June 10th, 2022 California Board of Legal Specialization public meeting minutes. Hopefully you all have had a chance to review those for those of you who were present at the June 2022 meeting. Is there anybody who hasn't had a time to review those who would like to do so now? All right, great. Let's have a motion to approve the June 10th, 2022 open session meeting minutes,
So moved.
right?
Second.
Jeff Hammerschmidt moves to approve the meeting minutes, and you second?
Yes.
Okay, fantastic. All right, so we have an approval. Anyone else? Oh, I guess we have to do the vote. I'm sorry.
Oh,
So
the
we had
motion
let me clarify for the record, the moved by Jeff Hammerschmidt and seconded by Jake Yoon. And if you want to, please go ahead and take the vote.
of course. Vance,
Yes.
Hammerschmidt,
Yes.
Alano,
Yes.
Lee,
Yes.
Levy, abstain, Yoon.
Yes.
That is enough votes. The motion passes. Minutes are approved.
Great, thank you. All right, now on to staff reports. We have Leah Wilson with us here today, the Executive Director of the State Bar, who's going to talk to us about the State Bar strategic plan.
All right, thanks for having me. And I am going to give a very brief overview of the new 5-year strategic plan that's been referenced this morning. And then I will look forward to your very capable staff team and chair of helping to integrate the strategic plan conversation into the rest of your day and your planning. I'm going to take over the screen and let me pull up my presentation here. So as you've heard, the Board of Trustees earlier this year adopted a new 5-year strategic plan, and the plan covers the period 2022 to 2027. And I will say sort of at the start of this that there are no specific strategic plan objectives relating to legal specialization. And so I'm going to give you kind of, again, a high level overview of the plan. But I will say that to the extent that I can be clear and you're clear about the underlying principles reflected in the plan, I do think they can and should inform your work. And it sounds like you all are already thinking in that vein as well. So this plan is built around 4 goals. They all lead in with protection of the public, understanding that is the primary goal of the State Bar. We intend to do that through strengthening the attorney discipline system, ensuring access to and inclusion in the legal system, regulating the profession, and engaging our partners. You see here on the screen as well a new foundational principle that underpins the plan. This is a commitment to diversity, equity, and inclusion. We have been quite focused on that with respect to our licensee population. I'd say over the course of the prior 5-year strategic plan. In this one, you see an intention to focus on DEI for the State Bar as an institutional employer. And there are some steps we are taking in that vein under this plan. So goal 1, protecting the public by strengthening the attorney discipline system. This plan, another sort of new aspect of the plan is that it includes not just goals, but vision statements. So here you see a vision of the State Bar discipline system being recognized as effective, fair, and timely. And any of you read any of the news, you know that we have some work to do in this regard. But certainly here in goal 1, lots of focus on our discipline system. Each of the goal areas is structured around 4 key strategy pillars: DEI, policy and systems change, effectiveness, and consumer focus. So just to highlight a few of the things that are going to happen under goal 1, we are going to undertake a new analysis of racial disparities in our attorney discipline system. The initial study was completed in 2019. We will do another one, the second tranche, at 2024, and take a look and see what progress we have been able to make in that regard. We also have submitted to the legislature a new proposal for case processing standards for attorney discipline matters. Assuming that proposal is approved, you will see implementation of the new case processing standards and new reporting related to those standards. We also will be launching very early in 2023 a new Office of Public Trust, a public trust liaison. And most of you are probably familiar with the concept of an ombudsperson. So this is quite new for the State Bar. In 2023, there will be a formal public launch of this office under the auspices of Consumer Focus Goal 1. So moving on to Goal 2, this is right now where all of our access, admissions, and access to legal services work or goals are housed. So here you see the goal is to increase access to the legal system through outreach and education, improved access to legal advice and services, and a legal profession that reflects the diversity of California's communities. And again, you can see a vision statement where we hope to be. So goal 2, just like goal 1, is organized around these pillars. Just to give you some highlights of things that are outlined in the plan in this area, we have increasing the number of attorneys admitted on special admissions status with a particular focus on legal aid, the special admissions for legal aid folks, which I forgot the name of. I know Amy can jump in with it, as well as military spouse. So looking really to increase the numbers of people that we have admitted through those particular programs. We also have goals here around addressing the knowledge gap. You see that in the last prong under consumer focus. One of the things we know from our work to understand the justice gap is that one reason why people do not seek legal help for the legal problems they're experiencing is they don't actually know that the problems are legal. And so under this goal area of the strategic plan, we really have some intentionality around addressing the knowledge gap. Also here, there's quite a bit having to do with admissions writ large, looking at the bar exam. Hopefully you all are aware of a big initiative underway, the Blue Ribbon Commission on the future of the bar exam. We expect those recommendations to go forward to the Supreme Court next year, and we will receive direction from the court. We do anticipate there will be a directive to change the nature of admissions examination, and that will be something that we'll be spending quite a bit of time on over the course of this strategic plan period. Goal 3, we move into regulation. And I want to highlight this here because we are looking at promoting the ethical and competent practice of law to really prevent misconduct. It's an understanding that supporting attorneys in being ethical and competent is a way of protecting the public. Those of you that have been on CBLS for some time, or maybe are bar junkies, are aware of what I call like the great divorce that occurred January 1, 2018. This is when the bar split its trade association function and its regulatory functions. The trade association functions manifested in the California Lawyers Association, and we became the regulator. Our members changed from members to licensees as part of that. There was certainly a cultural shift in the organization that I think at the time was needed. But you see here in goal 3 a recognition that perhaps the pendulum swung too far in terms of our view that we could not do anything to help attorneys because we don't have members, we have licensees. We are a regulator, we don't help attorneys, we protect the public. So we really moved away from much of our focus on how to support the ethical and competent practice of law. With this new goal in the new 5-year strategic plan, I think you see the state bar coming back to more of a healthy middle, understanding that supporting competent practice is in fact part of protecting the public. So here, really what I anticipate a significant product out of this effort will be is a new 5-year plan on proactive prevention through MCLE, self-assessments, and other tools, really looking at factors that potentially drive discipline. So looking at some competency issues, practice management, some of the areas that we know are high risk for folks based on our discipline data, really investing upfront in trying to support attorneys to prevent any future contact with our disciplinary system. Our last goal area is broad, and it relates to how we engage with the public and others sort of from an institutional perspective. So you see here that the goal is to engage partners and stakeholders to enhance public protection, restore our credibility and our reputation, and really maximize our impact. So this area is where you see a lot of the changes, or under this goal, a lot of the changes that you've experienced, and some of them you went over a bit earlier, even with respect to how your sub-entity, your committee, is functioning. So one of the things that we've done under this goal area is we've already adopted new procedural rules. for the Board of Trustees and for all of the sub-entities. Not only have we adopted new procedural rules, these are the Rosenberg rules, but we're implementing them consistently for all sub-entities. Similarly, adopted public comment guidelines that you went over at the onset of your meeting, not just for the board, but for all of the sub-entities. This standardization is designed ultimately to increase access and to increase the ability of the public to participate in our policymaking. Some other changes that you will see here have to do with the kind of outreach that we are hoping and expecting, not just staff to have, but you as members of the sub-entities. One of the things that we want to do is have more intentional partnerships, both with legal sort of law affiliated organizations, but also non-law affiliated organizations that might be interested in our work. So one thing I'd ask you to think about as you continue in your planning discussion today and as you meet is what other entities are most interested in, invested in the work we do as specialists. The California Lawyers Association seems to be one that might come to mind for me, but there are perhaps many others, including the other organizations that certify specialists that Adrian highlighted earlier in this conversation. Do we have partnerships with these entities? Should we? Is there a way, again, to increase our partnerships in a manner that ultimately increases our reach and our effectiveness? Another thing I want to highlight that's addressed in Goal 4 is the fact that the State Bar will realize its 100th anniversary at the conclusion of this 5-year plan period. 2027 will be the 100th anniversary of the State Bar. So when we talk about wanting to maximize our impact, one of the things that we do want to do is lift up and highlight the great work that we do as an organization. Sometimes it gets lost in the negative headlines, but I think you know from the work you do, I know from many things going on at the bar, that we have quite a powerful and positive impact in many areas. And so I'd like you to start thinking about, in the CBLS world, the legal specialization world, what is it that you might want to lift up and highlight as we begin planning for the State Bar's 100th anniversary? And kind of the last thing I will say here is another emphasis that's really highlighted in this goal area and some of the strategies is on public participation. As I said, through the public comment process and meeting specific public participation, but also public participation on our various sub-entities, public membership. So you will begin to experience, if you have not already, our board really asking staff to work with the sub-entities to maximize the number of non-lawyers on the various sub-entities. And that is all sort of with intentionality around this vision that the public that we serve will have an active voice in State Bar policymaking. So that's a very high level overview. I encourage you all to take a look at our strategic plan on the website, which goes into a lot more detail. As I said, there are no legal specialization specific objectives in the strategic plan, but I think you can see sort of where you fit in many of the areas that I talked about, including the focus on regulation of the profession and increasing access to legal services. So with that, I'll just pause and see if there are any comments, any reactions, or staff. You've heard me do these presentations quite a bit now. So anything you think I left out that might be valuable for this group, please chime in.
Right. Well, thank you very much. We really appreciate that, Leah. Thank you for taking the time to share that with our group. All right.
Thank you, Leah.
Thank you. All right. And now we will go on to the orientation on Rosenberg's Rules of Order and other recent revisions to the Board of Trustees Policy Manual. And so Jean Krasilnikov, you will be leading us on this. Thank you.
I will. Thanks. Adrian, can you pull up the PowerPoint, please?
Of course.
Thank you. So as has been discussed a couple times today, the board adopted Rosenberg's Rules of Order to replace the 2-inch thick Robert's Rules of Order that some of us have come to use over the past many years. And this is all in an effort to increase accessibility to the public. And so whereas the Robert's Rules of Order is a 2-inch thick, brick that sits on our desks, the Rosenberg's Rules of Order are very short. They're about 10 pages long, and they are very straightforward. And so we're hoping that this is a great transition for all of you. So going forward, the Board of Trustees and all sub-entities, including the CBLS, will use Rosenberg's Rules of Orders as a guide when conducting meetings. And we recognize that there is going to be a little bit of a learning curve on this. So I will be here to assist you as we do that. And to the extent Rosenberg's Rules of Orders conflict with the Bagley-Keene Act or other applicable state law will control. Next slide, please. Some of the high-level pieces that we thought it would be helpful for you to know is that a quorum is a majority of the members unless a specific rule of the body establishes otherwise. So in our case, it is just a simple majority of members. The role of the chair is a little bit different under Rosenberg's Rules of Order. The chair is responsible for applying the rules of conduct at the meeting. The chair has the full right to participate in the decision-making of the body, including voting, but should strive to be the last to speak at the discussion and debate stage and should not make or second a motion unless no other member of the body will do so at that point in time. The meeting format is listed here. The chair announces each agenda item number and name. The chair invites the presenters to report on the item, including any recommendation that they might have. The chair asks the members if they have any questions for clarification. The chair calls for public comments, but ours is going to be handled in accordance with our policy, which we will touch on in a little bit. The chair invites a motion and announces the name of the member who makes the motion. Next slide, please. The chair determines if any member wishes to second the motion and announces the name of the second. The chair makes sure everyone understands the motion by asking the maker of the motion to repeat it, by repeating the motion, or by asking the meeting secretary to repeat the motion. So someone repeats the motion. And then the chair invites discussion on the motion. This is a little bit, just to highlight this is a little bit different than what has happened in practice before, which is that a lot of discussion ensues prior to making a motion. This flips it a little bit so that the discussion is focused on what the motion before the committee is. This will take some getting used to, but the idea is to put the motion on the floor, to then have discussion about it, and then to proceed with voting, which is just kind of the inverse of what has happened at meetings in the past. So once discussion is concluded, or if there is no discussion, the body votes on the motion. And if there's been substantial discussion, it's a good practice to repeat the motion once more before voting so that everybody understands what they are voting on. The chair will take the vote, which of course has to comply with the roll call voting required by Bagley-Keene when if the meeting is conducted via teleconference, and a simple majority is required to pass a motion. Once the vote is taken, the chair should announce the result of the vote and what action, if any, the body has taken. Next slide, please. So again, this is just reiterating that it's best practice to have the motion before discussion to help the body focus. Motions are made in a two-step process. The chair recognizes the member wishing to make the motion. The member then states, "I move" with the motion. Motions are initiated in one of three ways. The chair invites members to make a motion, the chair suggests a motion to the members, or the chair makes a motion if no other member is willing to step forward to do so. Next slide, please. There are three basic types of motions. The basic motion puts forward a decision for the body's consideration. So the example here is, I move that we create a 5-member subcommittee to plan our annual fundraiser. The next type of motion is a motion to amend. If a member wants to change a basic motion, so if they want to change the 5-member subcommittee, they would say, I move that we amend the motion to have a 10-member subcommittee. The third type is a substitute motion. So if a member wants to completely do away with the basic motion and put a new motion before the body, the member would do that by a substitute motion. So in this example, something like, I move that we cancel our annual fundraiser this year. There is a possibility of a friendly amendment. If it appears during a discussion that a change to the motion is desirable, a member might simply say, I want to suggest a friendly amendment to the motion. If the maker of the motion and the second accept the friendly amendment, it becomes the motion on the floor. If the amendment is rejected, the proposer can formally move to amend. There can be up to 3 motions on the floor at the same time. The vote proceeds in reverse order, so beginning with the last motion that was made. So in the example above, the body would first vote on the substitution motion, the I move we cancel our fundraiser altogether, and then they would move to the motion to amend and then the basic motion. So this can get a little bit confusing, but we will get through it. And it doesn't come up that we normally have 3 motions before us at once, but we will get through it when we do. Next slide, please. Other motions that are generally not subject to discussion and debate are motions to adjourn, motions to recess, motions to fix the time to adjourn, motion to table, motion to limit debate, and motion to reconsider. And present and voting, in determining whether a motion passes, we count all votes that are present and voting. We don't count abstentions. Though, if you abstain from a particular vote, that doesn't affect quorum. And this is just, again, just to highlight some of the things that are different. We previously had not done motions to adjourn or recess, so that'll be a little bit different in our process now, but something we can get used to. Next slide, please. Courtesy and decorum. It's best practice for one speaker to have the floor and for each speaker to be recognized by the chair before proceeding to speak. The chair should ensure that the discussion of an agenda item focuses on the item. Interruptions of a speaker should be limited. So these are limited to a point of privilege, which is an interruption that relates to the normal comfort of the meeting. So point of privilege, speaker, would you be able to speak up? Point of order, an interruption that relates to inappropriate conduct of the meeting. So for example, if the chair moved to vote on a motion that permits discussion without allowing discussion. Appeal a ruling of the chair. If the chair makes a ruling that a member disagrees with, they can appeal the ruling by making a motion. If the motion is seconded and passes by a simple majority vote, then the ruling of the chair is reversed. Calls for order of the day is to return to the agenda if we get off track. Withdraw a motion is a motion may be immediately withdrawn by the maker at any time, but the chair should ask the second if they wish to make the motion, and any other member may make the motion. Great, next slide, please. Public input. In addition to the procedures we outlined, the chair should tell the public what the body will be doing, keep the public informed while the body is doing it, and when the body has acted, tell the public what the body did. So this is just a little editorializing as we go along, explaining what is happening. Next slide, please. The Board of Trustees adopted a public comment policy that applies to all sub-entities, including the CBLS. And you've heard this, but I'm going to repeat it as we all learn and get used to it. The State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. These public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct business on behalf of the people of California in a timely fashion. Next slide, please. So we've discussed this, so I won't go into it in detail, but there's a new process for written public comment. And so we always encourage members of the public to make written public comment so that can be distributed to the CBLS members in advance of the meeting. It also ensures that a member of the public has an opportunity to communicate everything they want to, because as we know, sometimes verbal public comment can be limited. Next slide, please. And this is about the oral public comment. Again, we have a new process, which you heard about a little bit earlier regarding oral public comment. We're encouraging members of the public to sign up in advance. That will ensure that they are at the top of the list for making public comment. But even if they do not sign up in advance, there will be an opportunity for oral public comment. The chair will set a time per speaker of not less than 2 minutes per speaker prior to the start of the public comment period, so that speakers know how much time they will have to speak. Next slide, please. So again, this is just more of what you've heard, but one of the things that I'll mention is the chair does have the discretion to allow members of the public to speak following closure of the public comment period. It is of course not guaranteed that all who wish to speak will be able to do so, but generally at CBLS meetings, we have not had that issue. And after 2 hours of public comment, inclusive of a 10-minute break or up to the first 100 speakers, whichever comes first, the chair may declare the public comment session closed. But again, this is not an issue that normally comes up at these meetings. Next slide, please. This is just on reasonable accommodations. If any member of the public or frankly, any member of the CBLS requires an accommodation, we ask that you submit those requests 3 business days in advance of the meeting so that we can ensure that we're able to make those accommodations in advance of the meeting. Next slide, please. Maintaining decorum at the meetings. Speakers are given broad latitude so long as the comments they are making relate to the matters under the jurisdiction of the body. Members of the public have the right to criticize the State Bar's programs, policies, and services, as well as its officers and staff. However, members of the public who engage in conduct that disrupts, disturbs, or otherwise impedes orderly conduct at the meeting shall, at the discretion of the chair, be barred from further audience before the body at the meeting. And we've also have some guidance in the event of discriminatory or harassing comments during public comment period. The chair may, in their discretion, read the State Bar's anti-discrimination and anti-harassment policy into the record. Next slide, please. And that is this policy, which I will read for you. The State Bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. Employees must at all times treat other employees, job applicants, and persons providing services to the State Bar with respect and dignity in accordance with this policy. Likewise, the State Bar will not tolerate harassment, discrimination, or retaliation against its employees, job applicants, or members of the public by any employees or by any person with whom the State Bar has a business, service, or professional relationship. Next slide, please. After that, the chair would state that the comments are in violation of the State Bar's anti-discrimination and anti-harassment policy, and that those will not be condoned, are unwelcome, and or are inappropriate, and to interfere with the ability of those present to listen and understand. The chair will state that any State Bar employee who is offended or otherwise does not wish to attend due to the remarks is excused during the remarks. The speaker's time will be held during the chair's admonishment, and the speaker will receive their full allotment of time unless their comments disrupt, disturb, or otherwise impede the orderly conduct of the meeting. The speaker will be allowed to continue after the admonishment, and the chair may call a recess to allow staff or members of the public to leave and or to provide de-escalation. Next slide, please. Obstruction of view. The policy just states that in-person attendees shall not wear or display signs, hats, costumes, etc. in the meeting room that obstruct the view of audience members, and in no case shall be larger than a normal 8.5 by 11 piece of paper, and they should not be taped to a wall or doors, be illuminated, or attached to any pole, stick, or device. In the case of an emergency, the State Bar may waive or override the rules pertaining to meeting decorum, which is consistent with the Bagley-Keene Act. Comments and materials received during public comment will in full become part of the public record. So that should, members of the public should understand that as well. Next slide, please. And that's it. Are there any, I know we are all going to be learning this as we go along, but if there's any questions right now, I'd be happy to answer those for you.
I'm sure we'll have questions as we go along, but thank you very much. And Jean, please feel free to point out if I need to do something consistent with the new rules that I haven't done yet. So thank you very much.
You're doing great. Thank you.
All right, next we're going to go to the report on key statistical indicators for the program, which Janelle will be leading for us. So Janelle, thank you very much.
Good morning, everyone. So this is a standing item where we like to provide program metrics to give an idea of an overall program health. We would like to specifically identify areas where we've experienced a 20% change, increase, or decrease where applicable, when compared to the last year. This is the total amount of specialists as of December 1st of each year for year to date. Any changes, a decrease or increase, or under the 20% threshold. It is a total decrease of 101 over the previous year, which is only 2%. Family law is the only area that saw an increase. Admiralty and maritime law and franchise and distribution saw no change. And all other areas saw decreases, and the 4 areas specifically saw a decrease of 10 or more specialists are workers' compensation, 30, criminal law, 22, taxation law, 15, and bankruptcy law, 14. Here we'll be looking at the total number of applicants received compared by month for the last 3 months, which is September, October, and November, and the year-to-date for 2022 and 2021. Initial certification applications at each point in 2022 by the month and year-to-date totals were compared to 2021, and we see at least a 50% increase, likely due to that we typically see a higher volume of submitted applications in the even years as they would have gotten their results from the exam in the previous year. The recertification applications at this point by the month in 2022 were compared to this specific month in 2021, and we see a decrease of 28% or greater. However, when compared to the year-to-date totals, the differences are less than 20% decreases. Given specialists only certify every 5 years, and they may have certified as early as 6 months before their term date ended, which is generally or identifiable a pattern to submit an application time and volume at any time. Here we're looking at the total number of applications approved compared by the month for the last 3 months and the year-to-date for 2022 and 2021. The initial applications for the approved applications, we see an overall decrease of the 31% of applications across all the data points. For recertification applications, we only see an increase of applications approved in September each year with an 88% increase. However, when compared to all other data points, the differences in 2021 to 2022 are all 20% decreases or more. Applications are not typically approved in October of the odd years due to the staff work and the time required to administer the legal specialization exam that year. For initial certification applications are not typically approved in October, generally due to past complaints from new specialists who are charged the annual fee for the year for only 2 months of recertification or certification. The next slide, resignations. This is the number of resignations in 2022 are nearly identical to the number of resignations processed in 2021. The only deviating point is there a 42% decrease in resignations from November 2021 compared to November 2022. Are there any questions? Thank you, Natalie.
All right, thank you. All right, recent developments. I'm going to turn to Audrey and Adrian to discuss.
I think it's me first, right? So since our last meeting, I wanted to give you some updates on other activities in the Office of Admissions, like the bar exam. So we had the results of the July bar exam released on November 10th. For this July exam, 52.4% of applicants passed. We had attendance at this exam that was a little bit lower than prior July exams. July is usually our large exam because it's right after the spring graduation. So we were lower. We had 7,164 take the exam, and then, like I said, 52.4% of them passed. Whereas the prior July, it was about 400 more than that took the exam. So we do have some declining numbers of July takers. And then the attorney's exam had a 49.1% pass rate. So 379 attorneys took that exam. So those are attorneys licensed in other states, and they don't have to take the second day, the multiple choice. And 49.1% of them passed. So those are just some headlines about the July exam. The February exam opened October 1st. So far, we have 4,425 applications, of which 3,600 of those are approved. The final filing deadline for the February exam is January 3rd. Any bar exam questions? Everything's back to in person for the bar exam, by the way. I know we probably covered that at a prior meeting. Also, since our last meeting, we had the October first year exam, which is all remote. A new vendor that we used, we were piloting for this October exam for the first year. It's actually the same vendor we transitioned to for the item banking for legal specs. So you probably remember us talking about Prometric. So Prometric has a style of remote exam administration where they do live proctoring. So ExamSoft, which we used for the legal specialization exam as well, does record and review. So they record while you're through your webcam while you're taking the test, and then later they do levels of review, and then we as a staff also did levels of review. But the Prometric style is to have live proctors watching you through the webcam. We are looking at how the applicants like that experience because it was so different. They also have to get rooms scanned every so often, and that was a big change for the test takers because they have to get up and take their laptop and show different corners of their room and under their desk, and also like empty their pockets. And some of their feedback was not so positive about that because it was a little disruptive. But on the positive end, things like paper on their desk, or they left their cell phone out by accident, the live proctor would be able to say, hey, put that away before you start the live exam materials. So there's we had virtually no exam violations during the Prometric administered test because they had someone who was able to tell them, you know, you forgot to put that away. So there's pluses and minuses, and we're kind of evaluating which style of exam to continue with for the first year, and will impact the legal specialization exam as well, because that feedback is good for how we administer the remote exam for legal spec too. The pass rate was actually higher in this October exam. Probably nothing related, no correlation to the style of proctoring, but we had a 23.5% pass rate this October compared to last October where it was 14%. But it's a very small pool. It's 238 test takers for that first year exam. So that's kind of a exam roundup for you. Any questions?
Thank you, Audrey.
All right, so I just wanted to give an update on the legal specialization budget. As reported at the June CBLS meeting, the Board of Trustees, they met in May and reviewed the recommended spend down plan. The Board of Trustees approved that no significant spend down would be authorized or required until they have fully addressed the deficit in the admissions fund. The State Bar has conducted additional research and a legal analysis into our funds, the Legal Specialization Fund and the Admissions Fund. The State Bar, they will be moving and integrating the Legal Specialization Fund with admissions. This is expected to begin with the 2023 budget year. But the State Bar, they do maintain its commitment to support the legal specialization and provide resources for the administration of the legal specialization program within the State Bar. Does anyone have any questions regarding that budget update?
I just had a comment that this does mean that the surplus that the specialization program had is now going to fund the admissions deficit, and our specialty program funds will now be part of the general admissions budget and funds going forward. So just want to make sure everyone's aware of that. All right. Okay, on to the next item, item 4, business. Jeff Hammersmith, the vice chair, is going to take this one. So thank you, Jeff.
Oh, yeah, sorry. Thanks, Jeff.
So the CBLS planning items are engagement and focus, 2022 work plan initiatives, CBLS appointments for 2023, 2024 CBLS meeting schedule, and training topics for 2023. We hope to use this item to provoke a deeper review of and discussion of the CBLS roles and responsibilities, and to help us plan for our upcoming 2-year schedule. We also would like to continue this practice annually. CBLS engagement and focus. includes policy, legal specialist exam, education outreach and program growth, and attendance and participation. To make sure we are engaging all members of CBLS, we want to focus on the 4 items specifically: policy, legal specialist exam, education outreach, and program growth, attendance, and participation. Points provided in these slides are a few examples of the thoughts or suggestions that may help us achieve that item. We hope members will be able to provide additional thoughts or input for any area. Is there any input or thoughts, comments in these 4 areas?
I think as we move forward with Janelle, she'll kind of lay some of the groundwork for, what they have in mind for us going forward. But generally, this is a part of the strategic plan to help us become more engaged and start setting policies and thinking about rules where there are deficits that may help the program going forward. And so Janelle will go through and point out some areas where staff thinks there are some gaps in rules and policies that we may be able to fill going forward. And hopefully that will also have some of us thinking about some other rules and policies that we might want to see implemented for the program going forward.
If I might add, Adrian, actually, you tend to say this very well, so maybe you want to add sort of, right, the point of this being sort of utilizing the sort of the skills best of the CBLS members. We spend a lot of time as staff providing you updates, us talking at you and telling you, here's the health of the program, here's what's going on. But what we want to do is utilize your expertise, the reason that you wanted to be on this commission in the first place, to really help develop sort of the higher level policy about what we need to do in some of the important areas that deal with the exam. I'm really using your skills and your experience to help us build the program, define the program, ensure that we're applying all the rules consistently, understanding all of the places where we need to sort of think differently, right? This is an opportunity to look at trends in legal specialization across the nation and see what other people are doing and making sure that we're heading in the right direction. And really sort of doing some digging in and thinking about things like that is really the sort of direction that we want to take it. We think it will be more engaging and more fun for you. And that's something that we can't do without your input. And we really will rely on you heavily to help us move this forward. And so that's what sort of why we're thinking about shifting the conversation that has happened over the past several years in this direction.
And I think she said that perfectly. So the only thing I might add is within the CBLS, of course, it's only 7 members. So there's no way to have input for all of the specialty areas. But as Natalie mentioned, it's the functions. The CBLS will review, approve applications for new specialty areas or those related standards. So we, as staff, will be able to rely on our working groups to provide those updates to those, drafts to those, and then those would then go to you for your general oversight on those. So thank you all members. So I think this is an exciting opportunity to see where the CBLS goes and the program goes too. So
Great.
all right, I'm just gonna go ahead and turn it over to Chanel. Go ahead.
Okay.
Good morning again. So our first topic for the engagement and focus is policy. So we like to conduct in-depth review of the legal specialization processes and the written authorities, the rules and the guidelines that support those. We want to look and see if there's any gaps or a need for updating. Where are the authorities located? Are they either the LS rules, the state bar rules, a part of an application or website, another rule guideline that we are borrowing? The staff can look at other jurisdictions, organizations to compare their policies, look at other state bar units, updating or possibly creating legal specialization rules, guidelines as needed. And we will have some discussion later regarding a couple of areas that staff has already identified that may benefit from potential updates. Is there any comments or thoughts on this? Perfect. Go ahead and move to the legal specialist examination. The rules and policies. Violations, we have been borrowing the admissions chapter 6 rules regarding the bar exam violations, as well as the testing accommodations. Others are the results and the exam specifications. The administration is in person. Should we look at having it either every other year or annually? First, remote or on demand. These requirements for each exam type. Statistics for other jurisdictions that administer those exam types. And what do violations or pass rates look like between remote and in-person examinations? As we look at the legal specialist exam development and grading team, where and how to recruit? Should we have an apprentice program? Should we have term limits? Where do we need to diversify, as well as the requirements and qualifications? We look at the ledge versus edge team, which is the bar exam team, show their functions and expertise. As we look at the development for the questions for the exam, should we create and establish guidelines to minimize the performance? And as a part of establishing a 2-year CBLS schedule, we'll be able to prioritize the exam discussions for today. So we'll be able to be available for further review and discussion for next year, which is the 2023 examination year. Is there any members who have immediate interest in any of these areas?
Can I just highlight one thing about exam administrations? I think you heard earlier that the bar exam is now an in-person exam. And also that for our first year law student exam, we moved to a new vendor to look at how beneficial it might be to have live remote proctoring rather than a record and review at a later time. And the advantage there was that we had a lot of applicants who accidentally brought water to a session, and it eliminated people getting flagged for that. So I think one area that might be an interesting point of discussion for the group is, and we don't have to do it now, but I just think it's a consideration, is whether you think of in-person, it's important to go back to in-person or continue a remote exam, because we have that opportunity to discuss it. I know that we brought statistics, we brought a survey back at the one of the soon after the first remote meeting or remote exam administration for legal specialization. And I think that the survey conveyed that most people preferred to take it in that format. We did have to work around a few issues related to people who were able to bring paper format or access other documents in a remote setting. That was a little bit of a challenge. But anyhow, I think that we could look to this group to gather more thoughts on that process because we're moving into 2023 is an exam year. And so some of this would be really good to know in advance as we start planning for those examinations.
Yeah, so I mean, I think we have a great opportunity to set some policy in terms of, what we want to do in terms of how is the exam going to be conducted, how often are these specialty exams going to be conducted, and what type of, examination do we want to have going forward. So that's all great, and I think that's a great idea. We're going to be focusing on exam rules and policies in this year because it is an exam year. So we do want to prioritize that versus the overall policies for the program that Janelle will be discussing next. So
thank you, Natalie. So our education outreach and our program growth, we are looking to adding new specialty areas. Can this be done through direct certification or accreditation with national certifying organizations? And what areas would help to increase access to justice? With bringing in new specialists to existing areas, can this be done with on-demand testing, extension of results validity, marketing options and opportunities, conferences such as conferences, conventions, social media, publications, advertising, announcements, etc. Again, retaining our current specialists, creating an inactive status and staff waivers and expectations, more specialist engagement outside of certification, CBLS members, new specialty areas, working groups, and ledge. Surveying specialists, their demographics, their program value, their practice profile, which may consist of what type of tasks they are completing or how much work or percentage is dedicated to the specialty area. Program requirements or standards, waivers, the need for updating. What do we do with working group retention above? And other program thoughts and comments, processing times, communication, and do they know how to reach us and or find their own certification information? With reevaluating the current specialty areas, we're working with Araya to get the demographics of the current specialists, looking at staff and internal work needed to maintain the specific specialty areas and the amount of interest and growth. The possibly closing specialty areas by retaining those current specialists, which they can still be certified and recertified, but will no longer take on new ones. And we'll be reevaluating the current legal specialist subfields and reporting requirements. Are they current and relevant? As we move to educating the public, how do we promote the program and importance to the public? So these are just a few areas that we would like to touch on and get your guys' expertise on. And is there any questions or need for discussion?
Comment on this. This is the part that excites me the most. I don't know about the other specialists here, but I routinely encounter lawyers that have never heard of this. And like say, oh, legal specialist. They say, oh, what's that? How do you do that? And it's on the bar website. You go to the website, and they are stunned that there's a whole program here. And it's a really, I think we all believe in the program. That's why we're here. But I'm surprised how little even people who are in the profession are not 100% sure what this is, what it can do for them, what the requirements are. So I think this could be very helpful in the next coming years to get the word out on what we do here.
Well, an area that could happen is the time the licensees are sworn in. You know, if we had somebody that at the swearing in that just spoke for just a couple minutes and said, these are the 11 specialties and these are the other organizations. And if anybody is interested, you know, here's something you can scan to tell you, you know, to get an application. And, you know, if you think you want, this is what I've done with my associate is she got an application on day one and she's keeping track of everything that she's doing so that when it's time to apply, she doesn't have to do what I did, which is like, oh, I have to go find my trials, I have to go find my appeals, I have to go find all these things. And if we got people thinking of becoming a specialist from day one instead of finding out about it 5 years later, that might be a great way to promote getting more specialists.
And, you know, I think something also, we have the logo and things like that, but maybe something to enable specialist attorneys to have a little bit more visibility. I know we did a great thing for the senior specialists that they had pins and things, but I think they were 30 and 40 years as specialists. I think they probably were on the tail end of their career. For people who are actually out there in court, I think maybe there's something that, you know, pin some recognition that they could help kind of gently promote the program would be
Even
great.
every 5 years.
Yeah.
5 year, 10 year, 15 year.
Okay. Great.
And so I just want to respond to something you raised, Jeff, and that is the swearing in ceremonies. We used to have state bar sponsored ceremonies, and we're no longer doing those for financial reasons, but we have moved on to creating a virtual oath packet. So even I think we implemented that in 2020. at the end of 2021. So previously, we'd send a packet with all your information on MCLE, registering with the bar, getting a bar card. We now do that virtually, but one of the things we could include, as you've suggested, is in given that we're not able to do this at swearing in ceremonies, is material about legal specs as
Yeah.
part of that packet. Just as an idea.
Well, and I don't know what the bar's email policy is, but you have all of the members' emails and it would be not a bad thing to send out some email blasts about the program now and then.
And I know for criminal, Fresno County has the highest rate per attorney of specialization. And the reason is that the deputy district attorneys and the public defenders who become specialists get, when I did it, it was a 5% increase. And then it went to 2.5 when the recession, and now I think it's 3 or 3.5. So, educating the president of the Prosecutors Association or the Public Defenders Association to say, hey, here's the information on it. Because I know we have a lot in Fresno County. I think there's like 40 of the 310 criminal law specialists are from Fresno County.
Great program.
If okay, Michael, I know you were saying that you've ran into those questions. I guess maybe what types of things have you done to address those? Like,
Oh, well, kind of, unabashed supporter of the program. So I mentioned it. My specialty area, one of the challenges, I think all the specialty areas is very narrow. So bankruptcy we tend to know the 6 people who do it. But I'll just, like each county, the 6 people who do it. Like in my county, there are a fair number of bankruptcy attorneys. Santa Clara County, I think we only have 5 or 6 bankruptcy specialists. If you added San Francisco, even San Francisco, I think has 12. That seems small, considering that practice area. And I was saying is, the top practitioners in bankruptcy in my area were not specialists. Not that they didn't want to. I think they just it didn't connect. But it seems like if we could connect with those people, that would be really ideal. Because it seems like we're punching below the average number for the county that I'm in, kind of opposite of what Jeff is finding, punching above the number. We seem to be undershooting it.
if okay, I'm gonna keep your name down as interested in that area. And then when we do our further research,
You're hired.
I'm gonna keep it down. Thanks, man.
I'm excited about it. Thank you.
All right, and Janelle, if you could move on to attendance and participation.
So attendance and our participation, as we move forward, as we're planning out the CBLS schedule for the 2 years in advance, we like to start adding reminders, notification, and calendar invites once the calendar has been established. We would like to focus on the CBLS meetings, the work around the 2-year exam development cycle, which the legal specialist exam roles, reviews, and updates, and the administration work is in the odd years. Also, our other legal specialization roles and other ad hoc and unrelated work in the even years, which would be 2024. Our polling members at the beginning of each year, we would like for any known blackout dates in the upcoming years, looking for any conflicts with the existing CBLS schedule, the possibly adjust as they are needed. And see if there's any items, rules, or parts of the program that interest them, so we can assist in the research and they can present at the meetings. And any additional support and participation at the meetings, we like to understand that the CBLS is only 7 members, and it is important to have all or as many members attend each meeting. We also will hope to get volunteers for the specific items, and as well as the officers' staff may assign as needed. Slide, Adrienne. Oh.
All right, go back to Jeff.
Okay. This CBLS 2022 work plan initiatives.
Oh, and you know what? It comes to me. Sorry. All right. So for the State Bar strategic plan goals and initiatives. I just wanted to give you an update on all of the 2022 initiatives, let you know where we're at, and then possibly discuss thoughts for each of those. For this first initiative, re-examine guidelines applied when evaluating proposals for expanding certification areas outside of the State Bar's current offerings, with a focus on public protection and regulating the legal profession, with consideration to promoting access to justice. Establish and appoint privacy law consulting group, review research and recommendation of that consulting group, then present those findings to the Board of Trustees as appropriate. So the CBLS officers, they have selected appointments for the privacy law group. And then just as a quick reminder, that group, they are going to be tasked with studying the practice area to assess whether there is sufficient need and interest to create a specialty, as well as whether the area is sufficiently defined as to create a useful specialization. If that group does determine that certification in the area of law is feasible and appropriate, they will draft appropriate certification standards for review by the CBLS and then the Board of Trustees if you guys recommend moving it forward. All recommended applicants, they have accepted their appointment. So there will be 13 members of the privacy law group. It has 11 attorney members and 2 non-attorney public members. Those members will serve 4-year terms. For 2023, there are 2 officers. The chair is G1 Serrato and the vice chair is Ryan Davis. The privacy law group, they will begin meeting in 2023. They're expected to meet for 2 to 3 years, potentially up to the full 4-year term. Completion of this overall work plan initiative, it is pending the work of that group. So I wanted to see if anyone had any questions regarding this plan. Should the plan or wording of this be updated? Or maybe we take it off for next year and wait for the privacy law group to come back with something for you to review. Any thoughts, questions on this plan?
I think we're just waiting for the privacy law group to get back to us, so.
Okay, I mean, so do we just, should we just continue it each year?
I
Just
think
hoping we
so.
have further updates? Okay.
Yeah, I think we put the ball in their court. So
Yeah. So for the next initiative, build, implement, and train on examination item banking solution to increase the security and efficiency of the legal specialist examination development. So staff, we have completed system trainings and imported our question bank into the new system. And that system is through Prometric. We have reviewed the new bank and we have verified successful migration of all those questions. We are currently preparing training materials and are expected to get our exam developers into the system beginning this month at the latest next month. My questions, do you feel comfortable with this being complete and potentially removed from the work plan for next year?
I think so. It sounds like you've completed the task.
Correct. Yeah, we built it. We've implemented. I mean, the only one is training, but we are expected to get them in this month or once again the latest next month.
Do we need to make a motion to remove something from the work plan?
No, this is just discussion. I'll make this maybe this comment right now. So, all of our notes from this planning session, staff will review it. We'll come up with draft proposals, draft work plan. We'll review it with the officers to get their thoughts and possibly a finalization on anything. So, did you have something?
I was just gonna say this is a really big lift for the staff, a very huge effort. So behind the scenes, big congrats to get the item banking all entered. It was a lot of work. So
Yeah.
Great job.
Thanks.
and is there somebody like, is it the questions randomly picked or how are the questions selected from the bank?
The developers,
Okay.
our exam developers, they will be making the question selections.
Okay.
Next initiative. Create a procedure to ensure that specialists who no longer hold certification have removed the designation from their materials. Draft updated standards to include enforcement and consequence for failure to appropriately remove the designation or any references to specialization. So staff, we have worked with the State Bar Office of Chief Trial Counsel to draft a letter we can send to any licensees found to use the certified specialist designation when they are not actively certified. This has been, it's been pretty effective in getting those licensees to timely remove their designation. And actually work on this initiative is what led to us, led us to review the CBLS engagement and moving the CBLS to a new focus. This overall plan, it is pending completion of drafting updated standards. Staff, we do think that the standards can be updated as part of the new CBLS focus and review of all legal specialization rules and processes. My questions, should the plan itself or any of the wording be updated? Maybe removing that first paragraph or updating the paragraph to note that reviewing all of the legal specialization rules and processes. So not just standards regarding enforcement or consequence. Do we create an overall initiative for review of all, or do we want the specific one still? Any thoughts from members?
It sounds like this can be updated to be more general, given what we're going to be working on going forward.
Thank you. Next initiative, research impact of the remote exam, creating a post-exam survey, analyzing the impact of the remote exam on different populations, develop recommendations for future use of a remote exam. So staff, we did actually get to survey the applicants from the legal specialist exam in 2021. Preliminary review indicates that applicants prefer the remote exam environment. We are going to try and look to compare those responses to the different demographic segments. Responses could have been submitted anonymously, so it may be difficult, but we'll definitely try. Staff, we are currently planning to continue with the remote exam for 2023. So that's our hope moving forward for next year. We will be discussing the legal specialist exam rules and policies later in the agenda. But I wanted to get your thoughts. Should this plan or the wording itself be updated? Should it be considered as, or should it be considered as complete and removed from the work plan? Since our intention is to already move forward with a remote exam.
Seems like it could be withdrawn.
I'll make that note. Yep. Next. Explore outreach opportunities to first provide information to educate the public, to increase awareness and the importance of the certified specialists. And also second, prospective licensees, whether it's new admittees and current licensees, to become certified specialists. Staff, we have been attending regular ABA legal specialization roundtable meetings with various administrators from certifying agencies and organizations across the U.S. Recent topics included how to promote certification to licensees, maybe establishing a common designation across all certifying bodies, how to promote to the public the importance of certification. Staff, we do hope to continue participation in these meetings. I think that this will still be ongoing, but once again, thoughts on, does it need to be updated? Should it be continued? Also, if anyone has any ideas on how we can research as staff, any members interested in attending those ABA meetings? I realize I posed a lot of questions at once. I should have waited, but any thoughts on any of those? Ideas for either one or two, or maybe if anyone's interested in those meetings.
Mark was attending those previously, right?
Correct.
Okay. Yeah. I mean, I'm happy to attend those if no one else volunteers. If anyone else has a real interest, I would certainly step aside, but I think it would be interesting.
Mm-hmm. And then I think, Jeff, I know you said earlier about how to get those new admittees. we'll see what we can do within our capabilities, what's within our capabilities. So.
One of the things too is we could include something in bar bulletins.
Mm.
You know, every county, or at least most counties, have a bar bulletin. Most of them are electronic now. A few counties are still paper, but I'm sure they would get them to put something in at no charge.
Okay.
How about somebody writing a article about the program for the California Lawyer magazine?
Yeah.
That's a great idea.
How long do they want their articles? You know, like a lot of them are 750 words or.
Right. Could interview some specialists in different areas and,
Yeah. I'd be willing to
Talk.
participate in that.
okay, that would be great.
And I apologize, I was out of the room, so you probably already said this. But on any of these kinds of brainstorming how to get the word out, we can also, I'm not sure if you can have sort of a point person from the board, but we can work with, brainstorm with our communications office as well. And they might have some ideas that neither you nor we as staff would think of, just because that's the world they operate in.
Sure. Great.
Any other thoughts or comments on this work plan from anyone? No? All right. Next initiative, evaluate the legal specialization processes to ensure that those processes are supported by subject matter experts. Procure and retain diverse groups of SMEs to provide expertise and input specific to each legal specialization area, whether that's through our working groups or our exam developers and or graders. So staff, with the input and guidance from the CBLS, we hope to conduct an in-depth review of all of the legal specialization rules and policies, and also on how to retain those specialists. My question, as with the other ones, should this be updated, the wording at all? Should it be continued into the next work plan?
I think the procurement and retention of diverse subject matter experts for these categories is kind of an ongoing thing, right? So I would suggest we retain it.
And then for that actually finishes all of the 2022 initiatives. So thinking about 2023 goals and initiatives, considering this new CBLS engagement and focus, what should we consider as new goals and work plan initiatives for 2023? Where possible, individual plans should be tied to the strategic plan. And then once again, after today's meeting, we'll review any notes, prepare a draft work plan to present to the officers to get their thoughts, edits, and possibly an approval to move forward to the Board of Trustees for final approval. But thinking about this new focus, any members have any immediate thoughts or comments on what we could look at for goals or initiatives?
Well, I think given the focus for this year on going over the exam rules, that should be some component, looking at the exam rules and policies for the 2023 work plan. Does anyone else have any other suggestions?
Would there be any benefit to having, talking about the exam being it's every other year, would there be any benefit to keeping it every other year, but having, you know, about half the people take it 1 year and half, like you divide up the specialties? Would it be easier on staff if you know, the exam was given for certain subjects every 2 years, but then next year it's the other subjects? So you'd be dividing up, you know, not having 1 year where you don't have any and 1 year where you have all of them.
I think the volume is low enough where it wouldn't affect that too much.
So it's probably better to do it all at one time.
The only reason why I think that is it allows, I know this is totally self-serving, it allows staff to entirely focus like development in one year, grading in the next year versus having to juggle both at any given time.
So
But yeah, I mean, I think the volume it's we'd have to consider what areas have the most takers or what areas have the lowest takers. I mean, we could definitely look into it.
the only reason to do it would be to benefit staff. So if it's going to be harder for staff, we definitely don't want to do it. I don't know.
I still want to take a look into that. That's a good thought. So.
I mean, offering the exam, all of the exams more often is better for recruitment.
Yeah.
But that would take more in the bank.
Yeah.
Right.
Any other thoughts? New initiatives? No? All right. Thank you. Go back to Jeff.
Okay. CBLS appointments for 2023. Members, next slide. Members terming off include Natalie, myself, Norma Acosta, and Abe Levy. And we have 4 vacancies to fill for 2023. Latrell.
Morning, everyone, again. So as previously mentioned, the CBLS will have 4 vacancies to recruit for in 2023. There will be a loss of criminal law, family law, legal malpractice law, and workers' compensation law representation. The CBLS has generally prioritized the following criteria when considering appointments. The first one, prior volunteer experience, particularly experience drafting and grading specialist examinations. Number 2, having a range of specialties represented, including representation for each of the 3 largest specialty areas, which are estate planning, trust and probate law, family law, and workers' compensation law. And 3, allowing for diverse representation to the extent possible, which includes racial, ethnic, gender, sexual orientation, and geographical representation. With State Bar's focus on public engagement, staff will prioritize a second public member appointment to fill one of the available vacancies. Some questions we wanted to ask are, is the criteria still accurate? How and where could we recruit? And do any members have any thoughts or personal recommendations?
Question, relatively new here, so Natalie and Jeff and Avi and Nora, so.
You'll be the
Yeah.
Jake and Baby B and Grace are now.
Remember how many members we have?
Yeah, the ones. So I guess we need to study this a lot more in the last hour. But I'm assuming that you don't seek reappointment, or you plan to seek reappointment, or will the board be just the remaining?
Members can. So our past chair, he did seek reappointment for a single year because he would have termed off the year he was a vice chair. So he sought reappointment for a single year just to serve as a chair, which was approved. I believe the Board of Trustees currently did that with their current chair. He was reappointed for another year as chair, right?
No, not in that scenario, but we have a general rule that the people can sit for 2 terms, but we can extend by a year to sit as vice chair or to sit as chair.
So Jeff, you are eligible for an extended term,
Yes.
which I think would be very helpful, given the number of people who are terming off, to have somebody with your experience to continue on.
I let Adrian know I'd be willing to stay another year.
I think that would be fantastic.
Would Norma stand another term as a vice chair?
If she thought to seek that, yeah, if she wanted to submit her name as interested for a vice chair, I think that's a possibility.
Yeah. So we could, again, under the same policy, the term could be extended for 1 year, or we'd have to check 1 year or 2 years, potentially, to serve in that sort of escalated role of vice chair and chair.
Because there may be a period of time where we may have a small number of members, correct, that are active after 2023. That we might just have Jeff, myself, Grace, and Jake, and then it's going to depend whether Avi, Norma, and Natalie, more likely than not, won't be serving.
Right, so then we'll have new appointees.
New appointees will come.
Yeah, who will come in our place. And so then the other question is, how do we recruit for those new appointees? And one suggestion is that we reach out to someone that we might recommend in those roles, and particularly, the emphasis on making sure that we try to have somebody in these larger specialty areas if possible. To the extent that we don't, I believe Norma was our family law.
Norma was
a workers' comp.
Yeah,
Yeah.
I think that's
She's
one of the
workshop.
questions that Latrell had
Right.
mentioned, so.
She was, so we need to make sure that we, consider that as well. That we have some of these larger groups represented on the board going forward. So something to think about.
I guess
and
for a point of clarification for notes, so the criteria of having representation from those specific areas is, I guess, given the CBLS's new focus of more specific oversight or higher policy, we can of course recruit for those areas, but is that still one of the underlying criteria?
And then, I think it makes sense to look to the subject matter experts that are engaged in the working groups and exam development as potential nominees for folks to put their names in.
That's how I advanced. I was in the work.
Right, yeah.
And I'd love, Jake, your thoughts, because I think you're the only public member. And as you heard Leah mention when she was talking about the strategic plan, something that we're thinking about for the board, all of the committees and commissions is maximizing the number of public members. We are authorized up to 2 public members on CBLS. And so, we'd really be interested in sort of, you don't have to sort of bare your soul for the public on what drew you to CBLS, but thinking about what drew you to CBLS, what would be some ways that we could do some really strong outreach to public members and make sure that we can describe what a benefit they bring and how important it is to have public members on the board. Like, where do we outreach and what should our messaging be on that? You don't have to answer now if you don't have an answer, but it's something that I'd love you to think about, love your input on.
Well, I knew about the CBLS as I was, serving at the workers' comp specialization. And I was interested in, and some of you guys know Bob Burmis, and he recommended me to be on this board. So I think, just like the attorney representatives, board members, I think public members, regardless of what the specialization area, I think it's important for us to look at the formal, public member, and then reach out to them and see if they are interested in it, because they already had a commitment in the specialization. Then if they can bring their wisdom to this board, and I think that could be beneficial.
And that's consistent with with number 1, prior volunteer experience, that goes
Right.
back to one of the specialties.
Yeah. But I'm a little concerned whether the CME, the members would bring the same quality to this board going into the future. I don't know how they work, because, I was there at the workers' comp till the very last moment, Natalie, Amy. So for me, it's a little concerning, right? Because I have no idea what their function is like, so.
And what may also be helpful is looking how the board advances year over year, something for the more senior members on the board to kind of help train and help pass the baton on to the next ones, because I remember Mark, we had 2 cycles of meetings with him, but it looks like we'll advance one more, and then very quickly, it looks like Grace and I maybe be suddenly the senior people on the board, and something to gain the knowledge of Natalie and Jeff and Mark, and everybody who's gone before us, so that we don't lose institutional knowledge as people term out, which I think is a concern, that we might have a lot of institutional knowledge, sort of people, but then after their terms, we have to rebuild the wheel every time, which isn't so efficient.
Any other thoughts, comments, or maybe even questions at all?
Okay, I've been told that lunch is here. We have about 5 more slides to go through on this section, and then I think we'll move to take a break. That works.
Sounds good. Cool.
All right, next. Go back to Jeff.
CBLS meeting schedule. Right now, we're looking at for 2023, for all the dates in 2023 and 2024, keeping it on a Friday, March 17, June 9, September 1st, December 15th for next year, and for the following year, March 15, June 7, August 30, and December 13th. Janelle?
So we would like to look closely at the following CBLS meetings for, so the schedule closely follows the CBLS meetings from previous years. The staff can send 2023 and 2024 schedules to everyone after the meeting, including a contact and availability questionnaire. As a reminder, the CBLS meetings are scheduled according to the state bar year, which starts and ends with the September meeting of the Board of Trustees each year. Moving forward, the CBLS will continue to have orientation and planning sessions annually, generally the first meeting scheduled for December. 2023 will try to prioritize the LSX rules and policies, and 2024 will focus on other LSS rules and policies. Are there any? Are Fridays still good for everybody? Should we move to still having 4 meetings a year? Because the Board of Trustees, they meet 6 times a year. The Committee of Bar Examiners 7 times. And staff will be setting the privacy law group to meet 5 or 6 times per year. Sorry, too many questions all at once.
Oh, so I just want to say one thing. I want to offer one modification here, and that is for the March 17th. We just realized that it's the same day as the CBE meeting. And we have less flexibility on that date because we have like a second date on the CBE. So maybe change that if that's okay with everybody to like the week before. I don't know if it's the 9th or 10th.
Looks like the 10th.
It might be better anyway to move that meeting up, because if the exam application is going to open April 1st, then we want to have those exam rules and policies finalized. So I don't know, Adrian, if you.
March 10th's fine.
Yeah.
By the way, 17th is St. Patrick's Day.
Thinking that too.
We're gonna wear all green to the meeting.
And in terms of, anything that's a sort of a policy or guideline, we could certainly have finalized. In terms of the rules, if these require changes to the state bar rules, then there's a more complex process for those to get adopted. You would make a recommendation for rule changes, which would go up to the Board of Trustees for them to approve circulating it for a public comment period. Then the public comments would come back to you and you take a look and see if you want to make any changes to what was circulated based on the input that was received from the public. And then assuming you don't want to make any changes, you take it back to the board and they would approve it. So there are some more formal steps that are required for rules. So for some of these, we'll just, start getting them in process. But I think one of the reasons that you all are talking about, does this quarterly meeting schedule make sense, is because we are going to be looking at some rule proposals. do we want to have, do we want to sort of plan for some more meetings to make sure these rule proposals are moving? Do we want to keep 4 meetings and say, if we need it, let's, we can poll for dates and then we can add something if a meeting is necessary. Because typically, all rule proposals, whether to a request to circulate for public comment or for adoption, would go to the Board of Trustees at either their May meeting or their November meeting, and not the in-between meetings. And so you may want to have some flexibility to say, we're almost there, let's meet we'll have a 2-hour phone meeting off schedule to get this rule package ready to go. So you might want to have some flexibility for those purposes.
That's a good idea. I think that's the best idea, to keep the 4 and then to have the flexibility to add, a Zoom meeting that you could do, a lunch meeting that even fits in with people's schedule if they're having court, till noon and then back at 1:30.
But I do want to note one thing is that if the quorum of the group is going to meet, so this is a small group, so if we get more than there's 9, so more than
No, so 4 meet.
4.
4 is.
4 is quorum. So if more than 4 meet, we would have to schedule it, follow Bagley Keene, meaning it has to be posted on our agenda 10 days advance of that meeting. So it requires a little more noticing and also legwork on the front end. Not that it's not doable, but I think it's just important to keep in mind it's not as easy as like, hey, let's all call in at noon.
Right.
So that just adds some complication. And I also want to remind everybody that 2 things. One is that this year we had a really challenging time getting everybody together. So I don't know if it would be helpful to have target dates, and that way, to come up with the date when everybody was available, so people could work around that. Or if it's better to just leave this for, and then we'll work at it like we did this year. I mean, it's up to you. I just want to pose that as an alternative, because I know we had a challenging time finding common dates.
We couldn't meet because we didn't have quorum.
And then the other thing was to the point that you made, Michael, and that is it might be better to have more than 4 meetings too, because of some of the succession, issues that I think we want to address. Knowing like what kind of information would be helpful for our exiting members to hand off to the everyone who stays on board. All 2 members will stay on board.
I think for that, then how about we maybe let's say we'll keep like a hard 5 meetings, and then add other meetings as needed. Still considering Bagley Keene meeting requirements.
So my thought would be, I mean, if we went to 6, we could have 4 in person and 2 via Zoom, just to make it a little easier for folks to get to from wherever they are.
I think
for
in person, she was gonna.
Yeah, so we're gonna have to swap that order. Currently, the bar's policy is that all of the committees and commissions are slated for 2 in-person meetings a year, and the rest of their meetings will be Zoom meetings. Now, that's based on the fact that we currently have authorization. There were amendments that were made to the Bagley Keene Open Meetings Act that allow for hybrid meetings or remote meetings where and I'm not sure if you all remember this from before the pandemic, when we would meet in person. If we did a conference call, you needed to list your location on the agenda where you were participating from, and that needed to be open to the public, so they could see the decision-making happening, right? That's why we have public access to meetings. The law changed for a period of time to allow us, if we do those Zoom meetings, you don't have to post your address, you don't have to make the location accessible to the public, because we're making it fully accessible via Zoom. That statutory change is currently set to expire July 1. It's been extended before, and so it may be extended again. If it's not extended, we'll revisit the whole how many in-person meetings can we have. But for now, it's 2 in-person meetings, and everything else would be remote.
Okay.
All right. So any thoughts on number of meetings for next year then? Any further discussion on that?
Can I propose the second meeting of this year to June 2nd, if it's possible?
I'll definitely take a look. And then I see Avi had your hand up. I don't want to have you holding it up for too long. Did you want to go ahead?
Sure. So this is kind of a problem that I had over the last year, is that the meetings are conflicting with already meetings that I have in other family law organizations that I'm involved in. And the family law community, which is the biggest specialty, one of the biggest specialties, is very active in other kinds of things which I'm involved in. So, for example, I already know I can't make March 10, I couldn't make March 17, I can't make June 9th, I can't make December 1st. So I don't know what that means in terms of how helpful I can be as a continuing board member, how that affects the quorum requirements, and the way that I had it handled in my other organizations that I'm involved in is they all talk to each other, especially when it comes to family law, whether it's the Association of Certified Specialists or FlexCom, which is part of DLA, or the American Academy of Matrimonial Lawyers. They all talk to each other and they make sure that they're not scheduling meetings that conflict with the other organization. Whereas kind of the way I see it done here is there's no room talking, I guess, or it doesn't seem like any of that talking before the schedule was made, was had. I don't know. Maybe it was. I wasn't there. So I don't know what that means or whether or not I should personally resign from the board because I'm not going to be able to be there for any of the other meetings you have planned this year. And so maybe that's something we can have a discussion about, or maybe either offline or during the meeting. But it concerns me because I feel like it's kind of what's been happening over the last year. I've been, if you will, not as active as I am with every other organization that I'm a part of. And it kind of seems like, not that I'm failing, but this is not the kind of impression that I like to give as a member or board member of an organization that I've signed up to participate in. So I feel bad, but I'm not seeing how I can fix it. And maybe that's just me being a part of too many organizations, so shame on me. But also, it just seems there's lack of coordination before things are set in on a schedule. So I don't know what to do about that.
No, and I think that's why I think Janelle mentioned it. So we're gonna come up. We already have one for this year. So we have an annual questionnaire to get members' availabilities to see if they already have any known blackouts. Maybe something we'll add is what other I guess boards or committees that the members sit on, so that we can try and coordinate meetings around those as well. But the questionnaire we do have right now, we definitely ask for any known blackouts, and then if it may be even not yourself, I know Jake said that he wouldn't be available for June either. So if getting 10 members in for any of the dates that we already have, we can definitely move those around. Even for these, while they are here, and we'll share these dates with you, I just ask that you hold them just in case, but pending the results of those questionnaires, there's likely going to be some moves. Yeah. Because we really want everyone to be able to participate, and we really hope that you guys find these meetings, I guess, meaningful to you. So we want you guys, we want your thoughts, we want your comments. So we can definitely move it around to get as many of you here as possible. Thank you, Avi. Any other thoughts, comments? Jake, I got your comment. I'll look at the June date as well.
Thank you.
Of course.
And Avi, did you say, just looking at the ones on the slide, you're not available for any of the meetings in 23?
That's correct.
Okay, yeah, so we'll want to address that.
Yeah.
All right.
And then Natalie, you asked this question. I don't know if everybody got the answer, like how many meetings?
How many meetings? And so Jeff had proposed 5 meetings with the ability to schedule in more on a flexible basis. Does anyone have a different thought than that? So I think let's go with that.
So Adrian, what about maybe sending, 3 proposed dates for each meeting and then everybody can respond?
Oh, that's a good idea.
And then, there's probably going to be somebody who can't make a meeting. We can't accommodate maybe everybody, but that could narrow it down to all of us or maybe only one of us being able to not attend.
Great idea. Thank you, Jeff.
Sure.
Great.
Any other thoughts, comments on this one before we move to the next?
Is there any reason why we would want to have, like, timing of things, we would want to have 2 of the 5 pretty close together? Or should we want to kind of spread them out evenly?
I can't think of anything immediately.
Well, there were the dates the board does look at rules or petitions.
That's what I remember. What I was thinking she was saying is
Yeah.
that there's
May
like
or
a certain
November.
time frame where we've got to get a certain amount of work done, and maybe 2 of them need to be done only a month apart, and then the others are spread out. We could certainly do that.
Okay. Yeah.
Yeah, we might want to front load some meetings on the rules so that we can get it to the Board of Trustees in May.
So do two before they have a meet in May, and then spread the other 3 out.
Yeah, usually summer would be spread out, right?
Yeah.
Because we don't have it, because we have early June and no meeting in July and perhaps like late August or early September meeting. So that really, that's a good spread, I think. Yeah.
Well, and I also thought, I'm just looking, March seems like a late start if we have a lot to do this year, right? So maybe.
February.
Yeah.
Do February and April.
Mhm.
It's a lot.
Cool.
Great.
All right.
All right, we have one more quick topic to cover before lunch. So Adrian, if you want to talk about training topics.
So for training topics for 2023, I wanted to get thoughts from members on anything that you'd be interested in seeing or presented to the CBLS. Just a couple things that I had initially thought of specific to the exam, given that 2023 is an exam year. The training or the testing accommodations process, it is being updated. We can try to coordinate and get a presentation on that new process, as well as on the grading process. I can definitely see if we can have one of our ledge members come up with a presentation to show to the CBLS. Grading is confidential, so I think that presentation may have to be done in closed session. We'd have to look at the rules, but that's something that we can definitely look into.
Is the grading process different than it was when we had the different boards for the different committees for each group?
I think the main difference is it's no longer volunteers, it's paid specialists. And actually, I mean, it may have been a result of COVID, but the last 2, well, at least the last one, it was done 100% remote. So all grading, we didn't have any in-person grading meetings. And that was the first time that we did that.
Well, but also they're led by the EDGE team members when, or I should say ledge team members. So they follow the format of the bar exam. So it may have changed a bit because, the leads are people with over 20 years of experience in whether it's exam development, pre-testing, or grading. And so the format might be a little different in that sense.
Yeah, so grading is one of those things that that I could say benefited from the pandemic. So one of the things that I know for the bar exam, for example, that we had been always aware of is the diversity of graders. And one thing that we were not diverse in was geography. And that can lead to other diversity factors. Because there was in-person grading. You had to come and you had to pick up the box, you had to do the in-person calibration. And so all of the graders were from the Northern California area, San Francisco, Sacramento, primarily. Because the grading is done remotely and you're not physically picking up the copies of the exams, we could do the calibration remotely. We learned how to do it effectively remotely. It gives us the ability to solicit more graders with greater diversity across the state.
Great. Right, anyone have any thoughts on training that we would like to have as a board on topics? Want to learn more about the program? What would you like to know?
What about having a speaker from another state that's like the head of specialization to kind of just get a perspective of what they've done? Like New York or something. Florida, Washington.
Jake will pick which state.
Was Florida at that ABA meeting? I can't remember.
Oh, I can't remember.
Yeah, and they do, one of the states that does
At the North
their
Carolina.
meeting, their tests are on demand, which I think is also
Oh.
good. And to hear what their outreach is like.
Right.
I will say, I think the gentleman was from the MBTA. He did a presentation at one of the ABA meetings on the things that they're doing to try and help inform the public. They had a couple YouTube videos. It looked like it had pretty good production value. I mean, if interested, I can reach out to him to see if there's anything that he can present to us. The MBTA is already one of our state bar accredited organizations. So maybe we can definitely relate it to that too, but.
Well, yeah, you and I looked at like the numbers of lawyers versus the number of specialists, and it's about 1 in 40 in California, just 2.5%. I'm wondering maybe what states have a significantly higher percentage of attorneys who are participating, and what are they doing that we could maybe do to improve to increase those numbers? Because I thought that number was pretty small, that it's 2.5% of all attorneys. If you look at physicians, the amount who are board certified is a much higher percentage than that. Good idea.
Any other thoughts on anything you'd like to see?
Maybe in that training that we should have our Teresa from communications come and we can do some brainstorming, some of those outreach ideas.
And Jake has one.
Right, Jake?
Yeah, perhaps it's unrelated question. I know some years ago, I was able to go to some of the conferences, auditing. And I think at one certain moment it stopped.
It resumed.
It resumed.
Yeah, so CBLS members, our graders, our developers, anyone in our working groups, they are able to. We should probably encourage it more. You can submit a request to audit a CLE activity or a legal specialist CLE activity. It would be free of charge. You would still get credit. You would just have to submit one of our review forms just to let us know how they did. But that is something that's available to all members.
All right.
That's probably a good point to help also encourage participation. I mean, it definitely seems like something you guys were interested in. So.
All right, sounds good. All right, so that takes us to the conclusion of this section. And before we get to the next one, would anyone like to move that we take a lunch break?
I'd be happy to move for that.
All right.
At least
I second that.
All right, Mr. Lee moves for lunch break, Mr. Yoon seconds, and may we take a roll?
We just need to define how long.
Okay.
How
Great.
long?
How long?
30 minutes?
30-minute lunch break. We'll resume at 12:50.
Okay.
Okay. And so the motion by Mr. Lee is to take a lunch break then and resume with the open session at 12:50 p.m. Seconded by Mr. Yoon.
Vance,
Agreed.
Hammersmith,
Yes.
Alano,
Yes.
Lee,
Yes.
Levy,
Yes.
I'm sorry?
He's muted.
Yes.
Oh,
Please say
thank you.
yes, I think.
You, yes. Okay, that is enough, folks. Let's break for lunch and rejoin at 12:50.
All right.
Thanks, everyone.
Big controversial positions here.
Well done.
So we'll meet.
No lunch for me.
Go ahead, now.
All right, welcome back. We are back to continue with our open session, and we are on to item 4B, which Jeff is going to lead. Thank you, Jeff.
All right, thank you. So we're
I'm gonna switch slides.
So this is going to be a discussion of legal specialization rules and policies. Next slide. Okay, we'll be discussing certification status, certification maintenance requirements, appeals, exams, other and next steps. And staff have completed a preliminary review of overall legal specialization rules and have identified some areas that could could require or benefit from updates. Staff has categorized these into the following groups: certification status, having the designation, removal from the program, and enforcement; certification maintenance requirements, which are fees, continuing legal education for legal specialists, recertification, waivers or modifications; appeals, informal conference versus hearing, exams, results, testing accommodations, violations, fees and refunds, and other and next steps. Any areas to look at? How would CBLS prioritize identified areas? As mentioned during the planning session, we will be immediately focusing on review of the legal specialization rules and policies next year. While the review of legal specialization rules and policies would then begin in 2024, we still wanted to present these items to see if members had any additional thoughts or suggestions regarding this area. Certification status. Areas are certified specialist designation, removal from the program, and enforcement. And Latrell.
Thank you. Certified specialist designation. So currently, LS statuses are certified or not certified. Staff think adding new statuses may help with specialist, i.e.
You're breaking up, Latrell.
Testing 1, 2. Am I good?
Go ahead. Yeah.
Okay. I'll just start from the beginning. So currently, LS statuses are certified or not certified. Staff think adding new statuses may help with specialist status, tracking, and program retention. For example, inactive or emeritus statuses. Removal from program. There is no direct relation between a licensee state bar status and their LS status. For example, when a licensee's state bar status changes to inactive, not eligible, etc., their legal specialist certification status remains active. Rule 3.124 provides that if State Bar intends to suspend or revoke certification, we must first notify them in writing and give them 30 days to respond. Staff believe that possibly creating rules specifically tying state bar statuses to LS statuses could help internal processes. Enforcement. So currently, there are no rules or guidelines for enforcement. From the letter template staff sends to remove the designation, licensees are informed that, quote, non-compliance could lead to referral for investigation and potential discipline. I believe adding this to the rules or other guidelines could help prevent continued use of designation ahead of time.
Any members have any immediate thoughts, other ideas for any of these items?
So there could be an amendment to that rule. Basically, it's due process under the 3.124 to give them notice in writing and 30 days to respond. But it seems like there could be an exception to that where if you are inactive or you're not eligible, that you're immediately not during that time period considered a specialist.
Right, we should have a thing where the specialization goes inactive with the bar status, or is suspended with the bar status, or barred with the bar status. So I think that makes sense.
It's similar to like professional license discipline. You normally have these due process rights, but like for a physician, the moment they go into a jail, as an inmate, they are immediately suspended from the practice of medicine until they come out. So I know it can be done, and it just seems like for somebody to be able to represent themselves as a specialist during the time they're not eligible for practice doesn't make a lot of sense.
And then also, I do think that it bears looking at some rules and policies going forward for an inactive or emeritus status for specialists who are maybe not practicing in their specialty as much, so they don't meet the current qualifications for recertification, but don't want to lose the specialty. So, that makes sense.
And we might have to, it probably tracks pretty well, but the distinction for some of the statuses, because I know like with the bar, you could have the inactive status of that you temporarily are not practicing. There's the status of the judicial office and things like that. I'm not sure, maybe we need something for that. It may happen every once in a while, of whether they have a specialist status that's different.
Right.
That is actually the only existing waiver right now.
Oh,
Is for specialists who are engaged in judicial service.
Okay, yes.
That is the only existing
One, yeah.
Any other thoughts on any of these, the designation, removal, or enforcement?
I mean, one thought I had, Adrian, you and I talked about briefly before, was that when they become a specialist, that they agree that if they resign or become ineligible, that they'll remove.
Oh, yeah, that's right.
Take it off their website. If they have their business card has it, don't use that business card or letterhead, change letterhead, marquee. A lot of I see offices where we have the attorney's name and then we'll have legal specialists in that area, that all that should be removed within 30 days.
No, perfect. Any other thoughts, comments? All right.
Okay, next is certification maintenance requirements. And those include paying fees, the continuing education, recertification, waivers or modifications. Janelle?
Thank you, Jeff. So one of the four are fees. And so in March of 2022, the CBLS approved permanent fee waiver for any specialist enrolled in the State Bar Pro Bono Practice Program. We'd like to know if this should be formalized in the rules or anywhere else. As well as doing so, may this help encourage participation in the Pro Bono Practice Program if known ahead of time? Any thoughts on that?
I think it's a great idea.
And then, I don't know if the CBLS has any immediate thoughts, but just thinking, like if we do add it to the rules, it will have to fall under those, the public comment period, going to the Board of Trustees versus if we added it to some other part of maybe just the State Bar website where it's still publicly known and it's still available there. But those are just some things to consider as well, like where we're putting it.
You can avoid all that by just putting it on the website.
Potentially, yeah. Depending on where it goes, there's different processes, but I think if we're updating the rules specifically, that's going to be the longest process.
Okay.
I guess, yeah. In terms of priority, like how high of a priority is it to making that known and where at?
Next is the legal specialization compliance legal education. So all standards for each area still reference the past reporting requirements for reporting 60 hours of the compliance every 5 years at the time of their 5-year certification. Under rules adopted on January 2014, the reporting is now done every 3 years, done at the same time as the general MCLE reporting. Standards for specific areas also still note LSCLE subfields requirements, which were permanently waived by the CBLS in 2017. For example, the certified specialist in estate planning, trust, and probate law previously had to complete courses in at least 3 of the following LSCLE subfields: incompetency planning and administrative procedures, estate planning, gift and tax return preparation and audit, administration of descendants' estates, and contested litigation regarding the above areas every reporting period. Now, those specialists may complete the 36 hours in the LSCLE requirement in any combination of the estate planning, trust, and probate law compliance without a minimum requirement for any of the subfields. Completing all, for example, they can complete all their 36 hours in only A, in the competency planning and administrative procedures. So staff will work with subject matter experts, which is the working group, to review and update standards to reflect: 1, is there a need for the subfield requirements in any specialty area? And 2, is a 3-year LSCLE compliance reporting period. Any? Okay. So recertification. Applications in certain specialty areas have identified requirements that may not always be possible and then that they're outdated. And staff can work with subject matter experts to review and draft the updates to standards. Waivers or modifications. The current LS rules only provide a waiver of requirements of specialists who are engaged in judicial services. Are there any other waivers, expectations to be considered?
I think we just talked about that. Perhaps waivers for folks who are inactive for any variety of reasons would make sense. They're not practicing at the moment, regardless of the reason, as long as they're not barred or suspended from practice.
Any other thoughts or comments on any of these? No? Awesome.
Okay, the next area is appeals. And the 2 areas to discuss are the informal conference versus the hearing and appeals generally. Adrian?
So for informal conference and hearings, currently the legal specialization rules, they do refer to informal conferences and hearings for applicants to contest application denials. Staff, we would like to clarify the process and possibly combine the terms. We don't typically see informal conference in any other state bar processes except for one, which is unique. So we're hoping to maybe replace that term with hearing, just for clarity and to help with applicants to understand the process. And then for appeals, legal specialization rule 3.125, it provides that applicants that appeal certification denials, suspensions, or revocations may file a petition for hearing in state bar court. We hope to be able to update that rule and make it clear that applicants are appealing application denials after that initial CBLS informal conference or hearing, whatever term we're going with. So we don't want applicants who are first being notified of a denial to immediately file an appeal with State Bar Court. Because the CBLS is the appellate body for these, we want to make it clear that appeals are first going to them, and then subsequently they would go to the State Bar Court if needed. Any thoughts on either of these two?
That all makes sense.
Yes, I agree.
Sure. Perfect.
Next, exams. The 4 areas are results, testing accommodations, exam violations, and fees and refunds. Staff have identified these areas as immediate needs for review and potential updates. Given the high priority and that next year is an exam year, we'll specifically have a more in-depth discussion on these items as part of the next CBLS agenda item. Other next steps, are there any other rules or policies of concern to CBLS that staff can begin looking into?
Yeah, so we want to know if there's any other process or any other rule or policy that we can start looking into so that we can at least begin that research for when we get to the 2024 CBLS year. And then also, how would the CBLS prioritize any of these areas that we already identified? And then if there are any interest to CBLS members so that the members could be available to staff to assist in research and provide guidance and direction as needed. And also possibly so that the members could then present those findings at a future CBLS meeting. As needed, officers or staff, we may consider assigning areas. Any thoughts on any other areas that we could look at? And also looking at these certification status, maintenance requirements, appeals and exams, how would we prioritize those?
Right. And I'm not sure if this is for the next section or not, but one of the things we talked about was, waiver of exams for people who are recertifying who maybe have lapsed at a certain point in time. For example, if you had someone who is a specialist for 15 years, they then drop their specialty because they haven't been practicing in that area as much, or they're just not practicing law in California. They come back and they want to recertify, that we could just have them go through the recertification without taking the exam again.
A very good example of thought.
So,
Yeah. That's a good idea.
Yeah. Any other thoughts, comments, suggestions, questions? Nope. All right. We'll continue to take a look at these notes and we'll definitely be coming back. So thanks.
all right. On to section C, discussion of the 2023 legal specialist examination rules and policies. So this is the focus that we want to have for this year going forward, looking at getting some rules and policies in places where there are gaps or suggested changes from staff, as well as getting any ideas and input from the board regarding any rules or policies that they think we should look into enacting if we haven't already. So we're going to go through and look at the results, testing accommodations, exam violations, fees and refunds, and then next steps going forward. Okay. Starting with results. Should the validity period be updated? Here, Rule 3.110B says that an applicant must submit the application within 18 months of the date on which the applicant took the exam. An applicant may request an extension of up to 18 months for completion of all requirements. Requests are granted for good cause shown. So often someone will take the exam when maybe they haven't met the 5-year practice requirement, or they haven't had enough hearings in a particular area. And so they're waiting to get the experience necessary to complete the application process. And so the question is whether or not the validity of the exam results timeframe should be updated, should it be increased? What do we want to do, if anything, with respect to the validity period? Does anyone have any thoughts on that?
think it would hurt to expand it. If you go to 3 and 3, 3 years and 3 years.
3 and 3.
6 years?
I think something like that's 18 months is kind of an awkward number, a year and a half, so do them like on even. you know,
Especially when the exam's only offered every 2 years, right?
Yeah. And I think a number of the, especially like bankruptcy had this, is you had to get a lot of recommendations and things, and sometimes it just takes time to do that. It's not as fast as.
I'm wondering if maybe we want to do away with the requirement altogether. It's like, once you take the exam and pass it, have you demonstrated knowledge in the specialty sufficient to meet that requirement? Or do you have to show continued knowledge going forward? Do we want to require retests? I mean, certified specialists are not required to retest once they've been certified. So,
Well, my only concern would be if somebody, let's say they had some reason why they maybe couldn't practice law for a significant amount of time and then were able to come in and get certified, but they weren't required to be keeping up on the law with continuing education like the current specialists are.
sure.
So somebody could come in 10 years later and just be really behind the times because they haven't been taking any MCLE and immediately be certified as their MCLE.
Okay, so like maybe if whatever the time frame is when they, like, if they are inactive and they want to come back to active, they wouldn't necessarily have to do we wouldn't just switch them to active, but they would have to do, I guess, some sort of proof somehow, like maybe like we have the application for initial certification, but maybe we'll have like not as much. So they need to submit 45 hours. Maybe they only need to submit 20 hours before just reinstating them. Is that what you mean?
It's kind of common.
Yeah.
Well, so somebody could take the exam and then, and we know if they're passing the exam, they're pretty up to speed. Let's say they go 10, 12 years and they don't practice law, and they come back in and sign up. They're probably pretty behind the times because during that time, they weren't required to take any MCLE. Right?
Oh, no, I get your question now. I'm sorry. I think I missed something. Okay.
Yeah.
So
I just think there should be,
Something.
no, we do. So while they pass the exam, they would still have to apply for initial certification. And then in that application, they have to stay within the previous 5 years. So if they pass the exam, they didn't practice for 10 years.
yeah.
If they start to practice again on year 10, they wouldn't be able to apply for initial certification until 15 years because they need to have been practicing in the area for 5 years.
Yeah.
They have to have a certain amount of tasks within the specialty area, and then also 45 hours.
Okay.
So the difference between that is someone waiting 10 years to apply, are we making them take the exam again before they can apply? And
Right.
I think you're leaning towards not.
Yeah.
Yeah.
It seems like having some time frame here, maybe 2 years or 3 years, but something to make sure that you take the exam and you apply and then promptly complete the requirements. I think just to make sure that the process keeps going. Otherwise, I don't think staff want a lot of open applications. We kind of need to complete the task or elect not to follow through on it. I think we probably would want to avoid a situation of a lot of test takers who then pass with a lot of pending incomplete applications, right? We want to basically get the application, get the exam passed and get the application complete, and not have long periods of times of basically these half and half people. I think that administratively seems like a bit of a hassle.
Right. Well, I'm going to pass it to Latrell so he can give us a little more information too that might help with the discussion. So Latrell?
Thank you. Legal Specialization Rule 3.110B provides applicants 36 months from the date they pass the exam to submit an application for initial certification before the results expire. This limited the eligibility of applicants to take the exam as they would have had to been practicing in the specialty area for 2 full years before actually taking the exam. Out of past practice, staff have offered an additional 3 months, extending results validity to 39 months, which allowed more applicants to sit for any given exam. With this additional time, Applicants who have been practicing in the area for 1 year and 9 months would then be eligible to sit for the exam. In comparison, at its November meeting, the Board of Trustees approved proposed changes to the admissions rules, which would eliminate the expiration of bar exam results, which is currently 5 years. Among the various reasons to remove the expiration, they provided example scenarios, including where an applicant passes the bar exam in 2001, gets admitted to practice law that same year, immediately goes inactive, and after 21 years returns to active status to practice law. The example points out that when they return to active status, there is no requirement that they reestablish they are minimally competent by taking another bar exam. Staff believe, at a minimum, the LSX results should expire after 5 years. This could maximize exam eligibility and registrations by removing the eligibility requirement, as any applicant could take and pass the exam and take the full 5 years to meet the 5-year practice requirement, potentially leading to greater program participation. Another thing to consider, using the example above again for comparison, where specialists leave the LS program, they are informed they are required to retake and pass the exam again in order to start the certification process over again. A question to consider: should the requirement to retake the exam be removed? If so, should LSX results have no expiration?
That gives a little more insight. So it sounds like the staff recommendation is 5 years so that someone has the full 5 years of their to meet the practice requirements to apply, which makes sense.
Well, and Latrell described how in admissions, we're no longer going to put a time limit on somebody's bar passage. So it will not, normally people had 5 years, so it will no longer become invalidated. So no one has to sit for a bar exam a second time, because that has happened. There are very few instances, but it's happened. But I think the other thing is that the difference between a bar exam and a legal specialization exam are so different. For the bar exam, you're trying to demonstrate that you meet minimum competence. And here, you're trying to meet
Higher level.
Yeah, exactly.
And you're
Extra level of expertise. So they're very different. Which is why I think the suggestion is 5 years and not that it never expire.
Yeah, so I think there's two things that we can, or two ways we can look at it. So does it expire for people who have never received certification yet? So people who are just new applicants, should we extend that validity period? And then for someone who took it and passed within that, they applied and received certification within that validity period, do we want to require them to take it again if they decide to come back to the program?
So anybody have any thoughts on the 5-year period? Does that make sense? I mean, that's similar to what Jeff was
Very
suggesting.
close.
I think it's in line with that.
Yeah.
So we're okay with that. And then as far as former specialists, whether they should be required to retake the examination, anyone have thoughts on that? We started to discuss it a little bit earlier. On the one hand, as Jeff mentioned, you want to have some certainty that they've kept up on the latest developments and changes in the law, such that they're still competent to hold themselves out as a specialist in the field. On the other hand, they still have the practice requirements during that time frame. I think it can go either way.
We could just have them reapply for certification. It's just, the difference is because they passed the exam and were certified already, they're just not having to take that exam again.
I mean, is there any way where we would have some discretion, or that the staff would have discretion to require someone to take the exam on a case-by-case basis? In the event, I mean, it's probably hard for you to administer that way, though.
We'd probably need some guidance.
Some specific
Yeah.
guidance of, like, if they haven't, well, I mean, if they haven't been practicing for a specific period of time in the field or something like that.
How about a suggestion of a conditional certification? So let's say, I stopped practicing or I was on medical leave for, say, 4 years and I came back, or say like fifth year, right? I just expired my, the certification period. However, let's say we give them a 2 or 3 years of, the proof of a practice. So that way,
What about, well, so they're already required to certify that they've been practicing in the field. So what about if we have a requirement that if you have been not certified for more than 5 years, you retake the exam, which is consistent with the exam results being good for 5 years. Right, so as long as you're certified, you don't have to retake the exam. And if you stop being certified, those exam results are still good for another 5 years.
Then like in year 4, if you reapply and then you
Right, you're
qualify,
fine.
You're fine. But yeah, that makes sense, because I think that's the whole point, right? Is that you're staying up in the field, and if you're not too far outside of the field, you stepped into it, and then when you recertify, you have to demonstrate your continuing education.
Expertise.
Yeah, expertise.
Yeah.
Should.
Sure. Any other thoughts, comments on results?
All right, on to testing accommodations. Adrian.
So for testing accommodations, currently, there are no legal specialization specific rules or policies regarding testing accommodations during the legal specialist exam. We have been applying bar exam and first year exam testing accommodation rules and policies to our exam. They are, excuse me, not they. The bar and first year exam testing accommodation rules and policies are currently being updated. We do believe that the proposed changes provide adequate guidance and coverage regarding the legal specialist exam TA process just generally. We do think that additional research into the process is necessary so that we can establish legal specialist or legal specialization specific rules and processes. This may be pending finalization of the general testing accommodations rules and policies. But I guess I just wanted to get your thoughts on what could we potentially look at in terms of specificity for the legal specialist exam. One thing that I wanted to note to maybe give you some thoughts. If a longtime practicing attorney received testing accommodations when they took the bar exam, let's say 20 years ago, and then they're now deciding to take the legal specialist exam, can they request same testing accommodations from 20 years ago? What would that process look like? What would any requirements be? Does it need to be specific to a practicing attorney? Any thoughts or comments on testing accommodation?
My thoughts is it would be the same as for the other exams.
And already for the accommodations for the specialist exam, we try to track what we do in the general bar exam closely, correct? We try to mirror that, so.
It is.
That sounds.
It is close.
To be hew closely to what they do there.
Right, I mean, whether or not you're a practicing attorney, the need for a test accommodation, is a need for a test accommodation be handled the same way, be a request for accommodation.
Members just might be interested to read the new rules out for public comment. They're posted on the website.
Okay.
If you wanted to review those, and then it might be in play for the upcoming exam. The public comment section of the website, and I'm sure they say testing accommodation rules revision, something like that.
Okay, makes sense.
Any other thoughts or comments on TA testing accommodation? All right.
Janelle will be talking about exam violations.
So currently, there's no specific rule regarding exam violations for the legal specialization exam. So we have used modified bar and first year exam violation rules and policies to apply to LSX. And it's important to note that admissions rules are for applicants that are non-licensed attorneys, and their rules wouldn't apply to licensed attorneys. Staff believe it's important to create the specific exam violation rules, including defining the process to review or appeal violations. And we move on to the in-person exam violations versus the remote exam violations. When looking at the exam violations and types of violations, are there any violations that would only apply to one exam type? And do those need to specifically be defined? Do we create a list of all violations generally versus lists specific for each exam type? For the remote violations and getting up or leaving the view of the camera, as well as in person exam, applicants can stand up and even go to the bathroom and completely leaving the view of the proctors. So are there any thoughts or comments on any of these for exam violations?
So I had a question. You noted that you thought it was important to create specific exam violation rules related to the review and appeal process for the legal specialist exam. Are there any other gaps that you see that would be necessary for specialist examination that's different than the bar and the first year examination process?
There's no other specific written authority that we can rely on.
Okay.
I don't think it's appropriate to rely on those admissions rules because they're like if a licensee or an applicant for our exam is taking or receives a violation and then they see that we don't have any rules or that maybe if we barred their rules, like this doesn't count to me. I'm not an applicant. Yeah. So I think that's our biggest gap right now.
Right.
Is having something specific that applies to licensees and
So
practices.
it would make sense to maybe borrow from those rules as a starting point, right?
To establish ours, it may,
Yeah.
it may.
I mean, the general test taking rules are going to be very similar, if not the same.
Mhm.
What you can bring into the exam, when you can leave.
And we did make, like Janelle was saying, some specific rules around the remote exam about leaving the web camera view and what you can have.
And isn't there at least one specialty that allows you to bring in written materials?
Right, so and that,
Yeah, tax, bankruptcy,
Yeah,
state, yeah.
What's the last one?
so.
Yeah.
Yeah, so we would want to accommodate for that.
Yes, yeah, and in that style that I was talking about, the record and review that because that is not, that gets all flagged. So someone having on that book open,
Right.
yes, it all gets flagged, but
Right.
yes.
Sorry about that, everyone.
Any other thoughts on violations at all? Maybe in the immediate, I do see this as an immediate need. Any volunteers to help us? Once maybe if we can draft out something to get some review.
I will take a look at it.
Yeah, thanks now.
I'm interested in exam rules. Special area of
Grace.
interest for me.
And you know what? I see Grace raise her hand. Go ahead.
Aw, thanks.
Oh, good.
Wonderful. Thank you, Grace.
Any other last thoughts, comments before we move to the next one?
All right. Fees and refunds with Latrell.
Exam fees. Fees are defined in State Bar schedule of charges and deadlines. So in 2015, we had regular exam registration fees, sliding scale from $350 to $950, laptop fees ranging from $150 to $225, and we had 828 total registrations. In 2017, we had a one-time reduced exam fee, sliding scale ranging from $100 to $400, and no laptop fees. We had 1,314 total registrations. In 2019, we had standard exam fees, 619 total registrations. In 2021, we had a one-time reduced exam fee, 590 total registrations. And in 2023, fees are set to return to standard amounts. Staff believe fees should permanently return to standard amounts moving forward. Refunds. Generally, fees paid toward the LS program are non-transferable and non-refundable, including LSX registration fees. We only recently implemented a refund policy during the 2021 LSX. Refunds and refund amounts were based on how far in advance an applicant withdrew and submitted a request for refund. We used the same dates and refund scale used for the first year exam, given at the same time as the LSX that year. Staff believe we should continue to use the same refund policy applicable to the first year exam, given at the same time of the LSX. The question we have is, should a LSX refund policy be formalized as part of the rules or any other guidelines?
Any thoughts on either of those, Fernando?
Any reason why we wouldn't just like allow them to, like if somebody had some reason where they couldn't take last minute, to have that credited toward the next exam?
We could look at that.
That's something we don't do with the bar exam, but it doesn't mean we couldn't look at it with specialization.
And the rationale behind that, though, is that some of that money's already been spent in terms of, like, say, you know, you're ensuring that people have met the prerequisites, like
Okay.
resources have been spent on that. And you know, right now we're on the online exam, so that may not be as much of a problem. But when it was an in-person exam, we've already paid for the facilities, the proctors, and so on. So,
Well,
but we could revisit it. I mean,
Yeah.
it's
the other option is not to give them a full credit, but to give them a partial credit.
Right.
15% restocking.
Yes. 50% restocking fee.
That's why we have.
open box fee.
You get more of a refund the sooner in advance you withdraw. But I think to your point too, to like the fees, like if we do standardize the fees and just continue with that moving forward, it'll be a lot easier to transfer those to a future exam versus like if we keep going back and forth for every other exam. I think that's something to also consider.
I will say though, the 1 year where we had the early registration got you a discounted fee
Mhm.
for the examination. It really helped us recruit people to take the
really?
exam. We sent out some email blasts to people in our field, inviting them to take the test and letting them know about the early bird discount. And we had a bunch of early signups.
Yeah. I think you're right. So the main difference for that exam was we still had the almost 100 volunteers in our vice positions who did help with that recruitment.
Right, we did it.
And for the last time where we had the reduced fees, we didn't have those volunteers available.
When we do get to the recruitment conversation, that is something to talk about, though. I do remember that sending emails from people who were specialists specifically to people that we knew in our field, they found it very flattering to be invited to the specialty. And it helped get a lot of signups.
Sense.
Overall, were there more exam takers that year than Adrian?
There were. That was 2017 had the highest ever.
1,314. That's
So really were.
That's
Mhm.
13.
over a quarter of how many we have total that are specialized.
And then the last time we had the reduced fees, it was 620 or 6 something.
During the pandemic.
Right.
Yeah.
And without the outreach about it.
Without the outreach.
No.
Correct. Any other thoughts or comments on fees or refunds for the exam?
Are we gonna charge the same for in-person exam versus remote exam?
There are still associated fees with having a remote exam, whether it's additional proctors or additional video reviews. Someone's got to have to complete that, and then it's also setting up. So I think we'd have to do some research into the cost differences between the two. But I think right now, regardless of what the difference is, it would be the same, regardless of in-person or remote. Any other thoughts, questions, or comments on fees or refund? All right, I'm gonna go to the next. So we did want to ask for other or next steps. Any other areas to look at for the legal specialist exam that we might not have covered or already looked at? No. Any areas of interest to CBLS members? Anyone want to help us cover any of these? Thank you, Natalie and Grace, for violations. We also have the results or TA.
I'm working on the article for CLA.
Jeff's booked. So, no, I
When
think,
I get that done, I'll volunteer for something.
no, anybody want
We'll take a look.
to take a look at the, exam fees and testing requirements? I will if no one will. So.
No, we'll talk. We'll take a look and see how much we have for each of these items, and then hopefully that gives you a better idea of what you're going to be volunteering for.
I'm happy to be in on the exam fees and testing.
Okay, sure.
And I could join, we could.
Sure.
A few of us on a phone call.
Thank you.
Yeah.
We're keeping you busy.
Yeah. Cost.
Any other just questions on the
So-
specialist exam?
The other question was in-person versus remote exam administrations. We're obviously doing the 2023 exam remotely. And then, after that, we can probably take a look at, how that all is going and whether we want to continue that, as well as look into, how often the examination is offered and whether remote examination gives us more options in that respect.
And then also for the exam specifications, should they be reviewed again? Should they be reviewed regularly? How would we schedule that type of thing? Just a reminder, so the exam specifications are any of the topics or subjects that you can potentially see on the exam to give applicants a closer idea on what they should be focusing on versus just thinking about the area generally. So should we look at those? Yeah, how frequently should we look at those?
I think they should probably be looked at pretty regularly because as the field develops, there may be new areas that become important and older areas that become obsolete.
Are you thinking like annually we can assign it to the work groups? or
Well, I
maybe
think before every exam, so every 2 years.
That happened in bankruptcy. We got this whole new subchapter that didn't exist when I took the exam. So that whole area wasn't even a thing when I took it in
Right.
2017.
Or some new case comes along and
Yeah.
abolishes a whole section
Yeah.
that's just no longer the law anymore.
in that new area that is, I guess, is that a high area that
It is.
Okay.
It basically was like a mini chapter for us. So we had like 7, 11, 13, and then there's like 11 plus now. So, and that just didn't exist. And it's very popular.
Yeah, for our exam, they changed the rules of professional conduct.
Yes, you have.
That's a big thing.
any other questions on the exams generally?
Adrian, I guess I had a thought, and maybe this goes back to training, but maybe trying to figure out, forecast what it would take with the banks to offer the exam every year. Like what would that take? How much work would that take? What's the inventory now like? Because I think that would increase participation if we could test more often, but what is the effort that would be required? And do we just focus on one area or a few? I don't know.
Something I think to that point just made me think, something to think about. If we do move to something annually, it doesn't necessarily have to be all 11 areas at once. Maybe we just have one area that we pilot with, like
Sample,
yeah.
see if it works.
So exactly. So it's not like we're just putting everything at it all at once. We don't even know. So it's just another thing to think about.
Yeah, if we did, probably make it one of the 3 biggest areas.
Right.
Yeah. I think it also we'll also have to take a look at our banks to see how many questions. I know like some banks have a lot more questions than others. So I think the one with the most questions would probably be the best to try annually, but.
Yeah.
Just something.
So Adrian, you probably also would need to get more drafters, right?
Oh,
mean,
yeah.
Question
So
draft.
that's part of the equation in terms of what it would take.
Right.
Any other thoughts, comments? Awesome, fantastic. This is a lot. I appreciate it.
Great. Thank you. All right. Well, that brings us to the end of the open session. We're going to adjourn to go into a closed meeting session. I'd like to remind the folks who are on Zoom that you have to log out of this Zoom meeting and join the closed session meeting. May I have a motion to close the open meeting session?
So moved.
All right, Mr. Hammerschmidt moves to close the open meeting session.
And I second.
Seconded by Mr. Yoon. Can you take roll,
You got
Adrian?
it. Vance,
Agreed.
Hammerschmidt,
Yes.
Alano,
Yes.
Lee,
Yes.
Levy. All right, I think we lost Levy.
We did.
All right. You?
Yes.
All right. We will be moving to closed session.
Okay, we're going to be moving immediately, so please log right into the closed session. Thank you.
Oops. Go ahead, Nelly.
All right, we're back in open session. We have now concluded all of our business on the agenda for both the open and closed session. There are no actions to report from the closed meeting session. Thank you to everyone for your attendance and participation in the meeting today. I'm going to ask for a motion and a second to adjourn the meeting of the CBLS.
So moved.
Moved by Mr. Hammerschmidt,
Second.
seconded by Mr. Yoon. Can you please take roll, Adrian?
Vance,
Yes.
Hammerschmidt,
Yes.
Lee,
Yes.
and you.
Yes, out of here.
Thank you, everyone. Meeting is adjourned.
All right, thank you so much.
Thank
Thanks,
you.
guys.
We leave these here for reuse or keep them?
It's for you. Stop the recording.
Yeah, you can leave them.